Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican police service Latino. I didn't ask you to interrupt me.
Is that correct?
Literally not true. Oh, for Trump's sake.
Good afternoon. Welcome to the Court of Public Opinion. I am the Recovery Addict. Come on in, take your seat. Welcome. We are here for day 3 of the Utah v. Tyler Robinson hearing. It's a half day. That's why we're starting late today. There's nothing that's been going on in court in this hearing this morning, so we're going to be going there in just a few minutes. Just getting everything situated, and as always, we're going to be bringing you the best audio from court that you possibly can get anywhere on the internet. And speaking of internet, we need Cindy Stovall to do your job. Cindy, you were first in chat today. That means that we're going to punish you for your promptness. Everything IP related worldwide is your responsibility. You are running the internet for all the rest of us. Please don't let it fail. We need you, Cindy. Cindy, congratulations. Thank you very much. I appreciate it. All right, welcome. We are we're awaiting the live feed. Oh, there I am. We're awaiting the live feed from court, from our pool feed. The camera for this hearing is KSL.
Thank you, sir. You're my new best friend.
KSL once again providing the camera in the courtroom, and we're just waiting for them to flip the live button. And then we'll be ready to go. We have a court watcher in court today. Number 2 in line this morning was Selena Kay. Selena was there also for day 1. Missed yesterday. She had some staying with family at home, so she's back in court again. This will be her second time in court, and we'll be hearing from her and her observations inside the courtroom, as mostly about the things that we can't see on camera or aren't allowed to look at with the camera. And as you know, if you follow this case at all, there are a few things the camera's not allowed to show. So Selena is there. I've already seen her in some of the various footage of the mayhem outside the courtroom as people are standing around hoping to catch a glimpse of attorneys or family or even Tyler Robinson himself being brought into the courthouse in an armored vehicle. We believe that the Don Jr. is not going to be there today, which frees up a lot of seats because security for the president's son took a lot of space. So more members of the public should be in today if that's the case, and we look forward to getting a few more people there in court. We're going to do a little recap of what happened yesterday and the day before, and what we expect to have happen today. Going forward in this case, because there are a few things we have not yet seen that we expect to see. There are a few things we've seen that we didn't know we were going to see. There have been some surprises, and honestly, it's been a little bit slow. Now, court sometimes is slow, right? The wheels of justice. This is not a race car, right? It's not made for TV. There are times where it's tedious and monotonous and quite almost painfully slow. And we've had some of those times in this hearing. We imagine that there might be some pretty exciting moments as well coming up as we have family making it into the court right now. So they're going to get situated there. Want some good stuff today, says Carolyn Taterville. I thought media took up most of the seats. They did yesterday, but also we had. There may be more seats afforded to the public if we don't have Secret Service taking up 10 spots in the courtroom. That's what I'm trying to say. But yes, it was true on day 2 or day 1, excuse me, that the media took public seats. They were there early, so they just lined up as members of the public and got in as members of the public. And And so, yeah, it's legal. Just doesn't seem right a little bit. But anyway, it is what it is. 15 people from the public got in today. That's awesome. That is awesome. See, there's an extra seat already up from the 14 we had on Monday. Has Erica been there? Yes, she has. We've had family on both sides that have been present in the courtroom. We're not allowed to show them on the stream, so the cameraman's being very good about that. That's one of the rules the judge has put in place. Blackbeard says, guys, my neighbor is back. Her husband didn't murder her and bury her in the backyard like I thought. Well, I guess it's a good day then, especially if you're the neighbor. Thank you. AZ DCS Oversight Group gifted a membership. Thank you very much, AZ. Appreciate the court watching you do as well. It's an important duty. All right, so let's see. The camera person did show Erica. Erica walked into the camera person's shot, and the judge has zero problem with that. Zero. The judge is aware that the camera person is doing his very best to follow decorum. And if he's shooting something, that's what it's called when you use a camera. I know it's terrible nomenclature for this, but if he's shooting something he's allowed to watch, and somebody jumps up and stands in front of him, he can't prevent that. And so, yes, Erica was shown as she was dipping out in a part where she did not want to be present. And she has the right. She is the victim representative in this case, and she can come and go from the courtroom as she pleases, as there are parts that she doesn't want to be there for, doesn't want to see. Or if she just wants to walk in and out, she can do that as well. Ali G in the UK says, Recovery Addict, can you tell my children to go to bed? Hey, kids, this isn't for you. Go to bed. Mom says go to bed. No, I tell you what, if you go to bed, she's going to head down to the corner store and get you to the chippy and get you fish and chips tomorrow, and a bag of crisps, and everything. Just lots of treats, lots of sweets tomorrow. A can of Lilt for each of you. What else do they have? It's been so long since I've been in England. Go to bed, kids. Go to bed. All right, we're going to be going to court here in just a minute. I will tell you that we fixed the issue with YouTube, where they mistakenly thought that yesterday, as we were live streaming on our Top Mark Media channel, which is in the media pool, our parent company, as we were live streaming court, they hit us with a copyright strike warning, believing that we were showing a cricket match in India. Now, I don't know how many of you watch cricket matches in India, but I don't think it looks much at all like the Tyler Robinson hearing. AI doing its good thing. We got that fixed. We're going to be back over there on Top Mark Media. Once again, that'll be a completely clean feed. The only thing that we're doing differently from the other clean feeds that are out there, so like on the Associated Press, KSLs, which is unlisted, a couple other, we're fixing the audio. We're making it easier for you to hear if you're wearing headphones, so it'll have sound in both ears instead of just one. We'll keep the levels high enough that you can hear everything in court, and keep a limiter on so that when Miss Nestor picks up the mic and sticks her mouth right on it and starts yelling at the judge in her nice reading voice as she does, it won't blast your eardrums out. So we'll have that going over on Top Mark Media. We'll also have the same feed going here with my commentary. Feel free to watch wherever you want. I will say on Top Mark Media, there may be chatting, but it's going to disappear. It's gone. It will not be there for replay. We don't really need the mods to pay too much attention over there. I'll keep an eye on it from my vantage point. All right. Let's see. We're at 2:43. Miss Nestor just now coming to court right now. So she's just showing up right now. She's walking into the courtroom. So we'll have cameras inside the courtroom in about 15 minutes. And in that time, let me tell you a little bit about what happened on day 1 and day 2, and now where we are on day 3. So,
hello.
Procedural matters, and unfortunately, you have not.
I think we've got everything. All right. Day 1, July 6th, the first witness up was Christopher Bagley. Christopher Bagley was a former UVU police officer. He's now with the Spanish Fork Police Department, which is just south of Provo. So it's still in the same region, in the same state, just a different city. He was the first witness. He had the duty to assign. He was assigned the duty to secure a walkway on UVU campus called the Hall of Flags. He was on one end of the Hall of Flags, and from his vantage point, he could see Charlie Kirk, where they were set up, the crowd, a couple different things. He had a very good vantage point, considering the event that happened and how things have transpired. So he witnessed a lot of things, and he also, as being a police officer, had a lot of access. And so he was involved in a lot of things, which is not normal for witnesses to a crime scene. Typically, a crime happens and then the police are called and then they respond. In this case, the crime happened, the police were there. That's why we're seeing the evidence come in like it does. So he heard a single gunshot. He witnessed Charlie Kirk, lean and, get struck. And he described the chaos with, people going everywhere. It was mayhem. He gave us a lot of information, including the little tidbit that it's legal to carry concealed on Utah colleges, on Utah state colleges, that you can carry a concealed weapon. And I happen to know, I've been there as a college student, and I was carrying one when I did. So there were a lot of firearms present at that scene, and there was a fair amount of police, not a ton. This was not like a massive security event, but there was a fair amount of security and police there just to make sure everything went okay. And of course, they had no idea that it was going to go all haywire. But he described the chaos. He inspected the Losee building, and Losee is spelled Losee. A lot of college campuses name their buildings after donors and things like that. So the Losee building was the building up above the amphitheater where Charlie Kirk was doing his event, and it had a rooftop that was terraced, had layers of rooftop, and it also provided a flat roof with an overlook that could see down to where the event was happening. And that's where he heard the gunshot coming from. So he went up there, inspected the roof, saw the place, the disturbed gravel in the flat roof, where someone had moved the gravel out so they could lay down comfortably on the roof and like a sniper's perch. And also he went and looked at the tech building, the security cameras, saw the video of the suspected shooter running across the roof after the shooting and jumping down off the roof. He went over there, found the boot prints, saw the scuffs on the roof, on the sort of like the trim on the edge on the eave. And did all that bit and let us know that there were no metal detectors or anything else at this event. It was sort of come and go as you want. Next, we had David Hull, who is a Utah Department of Public Safety employee, former SBI lead investigator, who's the second witness. And he talked the rest of day one and into day two. But he said it was organized chaos at the active shooter scene. He led the investigation with another person, so they had joint lead investigators. That's Brian Davis. We'll hear from him later on in the trial. He reviewed 16 plus hours of UVU surveillance, nearby Ring doorbell footage, identified Robinson using a DMV photo, silver Dodge Challenger with distinctive wheels on campus 4 times. Those 4 times, if you want, if you're on Twitter, Brandy Churchwell has done a really cool timeline that puts together the times and the visits and the order of the different security camera captures that Tyler Robinson was caught on campus. She tweeted that out, I think, this morning. She was talking about that. She's also following this case. Brandy's a good friend of the channel. She's amazing. Brandy Churchwell on YouTube and on Twitter. If we want to see that, that'll help put the timeline in place and why he was there, the different times of what he did each time. Because it did change. He had changed clothing, and one time he was limping with one leg straight, and one time it was at night when he came there. So it's all that. All right, let's see. So he came twice pre-shooting, at the shooting time, and then post-shooting early into September 11th. That we believe he was trying to get the firearm that he had stashed, and he was not able to get that because the area had been locked down. Let's see. We also, the courtroom was shown the videos of the shooting itself, and these were shown from multiple angles, some facing the booth that Charlie was speaking out of, and some from the booth facing out. But the judge did watch those. Some members of the court were able to watch them. The media was not allowed to show those, and so they were not shown. We did, however, with David Hull, and this was not on day 1, but on day 2, we did get testimony supporting the admission of evidence from all of the security cameras around campus that captured so much of the movements of Tyler Robinson. And they put them together in a big compilation, and originally they had like zoom ins and red circles and a little arrow and watch here and, you know, all that. Well, court doesn't like manipulated video, and it was not allowed in. They had to go back, sort of make a clean cut with just a wide shot, no zoom ins, and that was admitted and shown to the public. We have taken that because we got to see it from the camera person's perspective on the side, looking sort of sideways at a TV. I took that and corrected it perspective-wise, so you're looking straight on. It fixes the image so it's straight and you can see it a little better. Feel free to use that if you need anything. It's on Twitter. We posted that. We also showed it yesterday. So it's just a clean, easy-to-view version, so it doesn't look like you're squinting sideways at a television. So that's on my Twitter account as well. Let's see. Death penalty is on the table. Yes, death penalty is on the table. All right. A couple other things we had. David Hull finished his testimony shortly after that video was admitted. We then had a Jennifer Fuamuina. I don't know how to say her last name. It's a tough one. She's a sergeant at Utah Department of Public Safety when the SBI at the time of the incident. She was over evidence collection. She saw the crime scene physical evidence collection. She told us about the bolt-action Mauser 98 that was retrofitted to fit a 30-06 round. Usually the Mauser, I think, is a 7.92 round, which is not as common, but it is common for people to retrofit that gun to fit a more common round, the 30-06 being a common round. So that gun was retrofit that way. She talked about that and the dark towel found in the wooded area near campus, which is in the area where Robinson was seen entering on the video. We talked about the collected screwdriver from the Losi roof. That screwdriver was first seen by our first witness, that officer who initially went up there. She talked about that, and she gave us some DNA testimony where she told us that the male DNA on the towel and screwdriver matched Robinson and Lance Twiggs. That's Robinson's roommate and romantic partner. And statistics strongly supported inclusion, like trillions to quintillions times more likely with them as contributors, which means very strong support. This is as close as DNA experts will get to say this is a match. So this is a match without saying this is a match. We then did something quite interesting. We took a break with the state's case, and we're getting feed coming in from court. Let's go there. Okay. All right, our feed's live. Thank you once again, KSL, who's providing the pool feed for us. And let me turn on Top Mark Media. On air. And cut. Didn't cut. I need... Why is it not showing? Hold, please. Switch over here's. Have to get this sorted out on the Top Mark Media side. We took a break from the testimony from the state's witnesses and then went straight to went straight to a defense witness out of order. And this defense witness was Amanda Baker. She's the FBI DNA analyst. And this was where it got painfully slow as the defense asked very detailed questions about alleles and mixtures and possible inconclusive results and whether or not there's fallible and everything else about DNA. The defense feels this is very important. I agree. I just think it's important to be brought up at trial and not necessarily at the preliminary hearing, which has such a much lower standard that needs to be met. So that's where we are. Let's go to 7 here. Oh, I'm on the other one. 7 cut. Camera 1. I need to go to camera 1.
About to catch a whooping.
Fixed it. All right. It's confusing. I've got what's called two MEs. So I've got 2 different mixers on the same switcher, and I was switching the wrong one for Top Mark. It's now caught up, and it has audio enabled. Camera 1 on. Okay. That takes us to present time. Amanda Baker finished. She was only available yesterday, so she was questioned by defense briefly in cross-examination as well, and then the judge was a little upset because they did run a little bit long. So when we come back today, we expect to go back to Jennifer F. Fomoina. We expect her to be back on the stand and continue her testimony, or possibly go straight to the cross-examination if they're done with direct examination of that witness. So we might get some more of her today. So now you're all caught up, and you can also follow us over on Twitter. We post some videos and excerpts of things that happen here over there. Hey, Wilma, sorry. Can you hit the red record button on the hyperdeck on the fly pack? Down. Like a foot down. Left.
Is that correct?
Other left. There. That one. Thanks. All right. All caught up.
You don't put a diplomatic plate on a hoopty.
Thought she left. Amanda left. I'm not sure if Jennifer left. She left She'll be back. Remember, the defense has not crossed her yet. A little bit of earthquake there in the courtroom. Somebody kicked the tripod. We'll get that squared away.
I wear multiple hats, sir.
We're going to turn off the sound effects during trial, but you guys are playing them right now. Okay.
I'm not a camel.
Not a camel. All right, I think we're all set to go. We have 3 minutes before the judge is supposed to be here. He's been pretty prompt. I will say I think we're a little bit behind. We haven't heard, at least on the record, an official declaration that, Your Honor, I'm worried we're not going to finish in time. Now, we haven't heard that yet, but I think that's where we are, only because the exacerbation we are hearing in the
Happy
voices.
Birthday. You look good.
As some of these arguments go on and on, back and forth. The most common objections, which were up to, I think, let's check the count, up to 72 objections, which is a lot. We'll keep that on the screen there. 72 objections. Most of those being defense, literally only a handful of them coming from the prosecution. And those objections have to do with the use of reliable hearsay in the hearing. They object to it. It's a standard objection. They actually objected. The judge overruled them. They went to the Supreme Court. They filed an emergency, request to be heard to overturn the judge's decision. They lost at the Supreme Court.
Remember in the beginning when we started 110 years ago?
Yes, I do. And now we're back at court, and they're still objecting again. They've lost this battle twice over. It's in the law. Utah law allows the use of reliable hearsay in a preliminary hearing. It will be different in court. And but they're still fighting it. So it's preserved for the record, just in case the Supreme Court wants to overturn the case on appeal and upend all of Utah evidence laws at the same time. Rebecca says, "Are we sending Judge Boyd flowers before she leaves?" Buttercup sends hugs and sugars. That's a nice thought. We'll have to give it some thought. She doesn't leave till the end of the year, but I think it might be good to send her some flowers. We'll see what we can do. We've sent her flowers before. The response to the sound effects. There are a lot of sound effects. All right. We are going to back off of the commands. I'm going to turn the volume down so those won't happen. Mods, if you need me, hit me straight on the burner phone or call my direct number. Loves True Crimes, thank you for the super chat. Loves great place to watch. I was reading other chats and they were brutal. Thanks for bringing this up, Loves True Crimes. I'm not saying we're perfect here, and I'm definitely not perfect myself. But we do ask that if you're here, you understand that we all love watching court. We love getting the access to court, being able to watch and see the justice process play out in various settings and in various various criminal charges. I would ask that you be respectful. We don't need to call any names here. This is not the place to get in a fight with somebody who disagrees with you. If you can share your opinion respectfully, that would be good. Let's see, I've got a call coming in on the burner phone.
Call from Beautiful Matchy Ball. To accept, press 1.
We're about to go live. Just one second. Let me take this. All right. Thank you very much, Loves True Crimes. We do ask you to be respectful. I had to take a quick call there. I apologize. We're getting very close to the judge coming in. Steven says, I'm on the phone with RA right now. No, let's see. We do ask that you be respectful. Our mods are working overtime and underpaid to do this. This is a lot of work. You can't see everything they do because a lot of the moderation happens even before it shows up on your screen. But just trust me, especially in a case like this, they've been overworked. So we don't allow any comments about moderation. If you have an issue, I'm available on the burner phone. I do answer the burner phone myself. I can talk to you. We can get it sorted out and fix it. Sometimes we make mistakes. We'll fix those. If not, let me know. So, all right. Selena is in court today, Kristen. We do have a court watcher. She was position number 2 in the public line. So we expect to hear her during a break and after court as well. Here we go. Judge is back.
Session. Calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grumander, Ryan McBride, Lauren Hunt, David Sturgill from the state, County Attorney Jeff Gray, and Chris Ballard are also present.
Good afternoon.
Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser for Mr. Robinson, who's present in the courtroom, Your Honor.
Good afternoon. Mr. Robinson, good afternoon. And also for the record, the court recognizes the presence of victim representative, Ms. Erica Kirk. Good afternoon. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during the proceedings will not be permitted to re-enter until the recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. And as you note, the microphones on your tables are turned off, so please come to the lectrum when you're addressing the court. Second, the court will address the camera and still photographer, camera operator and still photographer. And if you both could come forward, please, to the lectrum. All right, could you both state your names?
John Wilson, KSL Television.
Tess Crowley, Deseret News.
Good afternoon. Could you state your roles for today's hearing?
Video recording and streaming of the proceedings.
I'm the pool still photographer.
All right. And have you both reviewed the court's standing decorum order?
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
Do you anticipate any difficulties complying with the order?
No.
Thank you both for your cooperation. Yeah. As we begin this afternoon, the court wishes to acknowledge the importance of safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone in the courtroom may be addressed by the court. For those individuals who are authorized to have a cell phone, please place your device on silent at this time so that these proceedings may continue without interruption. The court also expects that every person in attendance will be treated with the dignity and respect to which they are entitled to. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during their hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Finally, I wish to note that this preliminary hearing is scheduled to conclude this Friday at 5 p.m. I raise this as simply a reminder for the parties, particularly given that we have now reached the midpoint of this week. I recognize and respect the constitutional rights of all parties. When this preliminary hearing was set, the court allocated a substantial amount of time for both sides to address the matters they consider necessary and appropriate for purposes of this proceeding. The standard at a preliminary hearing is probable cause, and with that in mind, I ask counsel to remain mindful of the time that remains and manage your time appropriately so each of you is able to fulfill your duties to your respective clients within the time frame that has been provided. And with that, I wish to inquire of a brief overview on what is anticipated from each party in order the court has a roadmap on how we are proceeding for the remainder of this preliminary hearing.
Are we
First turning to the state, and if you wouldn't mind coming forward, Mr. Grunander.
Thank you, Your Honor. We anticipate presenting evidence through Agent Brian Davis this afternoon. Sergeant Jennifer Falmina is also present in the courthouse, and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow if we do get to her today, that will close the presentation of the evidence on the part of the state.
Thank you, Mr. Grunander. For defense.
So we're going to get the text messages today.
Good afternoon, Your Honor.
Good afternoon.
Michael Berg for Mr. Robinson. Judge, we have two remaining witnesses, Miss Oliver from the ATF and Miss Carner, also from the ATF.
All right,
And
and
what
to
about
both
exhibits?
parties, thank you, I
Thank you.
appreciate that. Do both parties anticipate any issues concluding their case? Obviously, there's variables, cross-examination, and kind of the fog of war that happens in court proceedings, but any party anticipate issues concluding at or before Friday at 5 p.m.?
Not from the state, Judge. Just want to highlight one issue for the court because it may be that the court wants to do some time management. The state is going to proffer a video 1102, a video recorded 1102. We have provided the state, I want to say about a day and a half ago, with proposed redactions because we believe that portions of it are not admissible, even in a preliminary hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. It may be that the court wants to look at the proposed redactions not while court is in session, but during some other period of time, because the transcript of the video, which we prepared and we provided to the state so the state could raise any concerns about the accuracy of the transcript. That's not an issue. The admissibility of portions of the video or the issue is about 20 pages, maybe 22 pages. So to use court time for the court to look at the proposed redactions may be an inefficient use of the time. I'm not saying when the court should do it. I'm just saying we may not want to do it between 9 and noon and 1 and 5 tomorrow or Friday.
9 and noon.
But it's going to come up
today.
today.
Fight?
So the question will be, when does the court want to engage in the process of reviewing a 22-page transcript that has proposed redactions? That's all.
I appreciate the heads up. Mr. Grunander, do you wish to be heard?
Yes, Judge. Your Honor, the state has received the proposed redactions, and we are prepared to address them when that time comes. However, we do intend on presenting testimony through Mr. Davis, through Agent Davis, and when we get to that point, when it's ripe for discussion, we can address the matter with the court. That would be our preference.
All right. Well, I'll address it as it comes. And to the defense, with the remaining time, do you feel confident that it is sufficient to accomplish your duty?
We do, Your Honor.
Thank you. All right. Does either party require the benefit of the record before we begin? To the state.
Patent files, thank you very much. I've studied the law since I was just a kid. Not a lawyer. It's a hobby of mine. But thank you for the kind words. Love that you're here.
Ryan McBride for the state, Your Honor. Just to address an issue that's come up and we expect to come up as we enter the second half of this preliminary hearing regarding the admission of exhibits. Under Rule 104A, the court must decide preliminary questions about whether the witness is qualified or a privilege exists or evidence is admissible. In so deciding, the court is not bound by the rules of evidence except those on privilege. And I'm bringing this up again because it's likely to come up and it is going to affect the procedures we use as we go forward. The court holds two roles, really, at this stage. One is a gatekeeper role on admissibility, and the second is the fact finder role as the magistrate. And I know you've referred to those two roles earlier in this proceeding. And the court, Rule 104A means the court can consider evidence even though its admissibility has not yet been determined in its gatekeeper role. And then, after it has been admitted, it can determine the admissible qualities of that evidence or that exhibit. And that is especially relevant at a preliminary hearing where foundational evidence is reliable hearsay under 1102B3. Even at trial, State v. Griffin, which is a 2016 UT 33 Utah Supreme Court case, the court has held that rules of evidence do not apply to evidence used to establish foundation for admission of other evidence. It's a quote from paragraph 33. So the point is, foundational rulings on admissibility can consider evidence that is not in and of itself admissible. That's proper. The second point is the courts of appeals recognize a presumption that the court considers, when acting in its fact-finding role, only the admissible evidence and disregards any inadmissible evidence. Most commonly, that comes up in a bench trial type case where prior bad acts evidence is admitted and it can have dual inferences. State v. Adams was one of those cases. That's 2011 UT App 163. And what it means is we know that a fact finder is not tainted by the judge's role as a gatekeeper, even though the judge as a gatekeeper considers potentially inadmissible evidence. It also means that the court doesn't have to distinguish which hat it's wearing as we go through the proceeding. In this circumstance, this hearing is taking place outside the presence of the jury. The state has laid and intends to lay and continue to lay foundation in open court. Such foundation sometimes will include discussion of the actual exhibits rather than just proffers, as well as foundation for the exhibits. Now, I don't think that there's any issue between us and the defense in understanding that kind of statement of the law. I think the issue that has come up is under Rule 104B, determinations of admissibility take place outside the presence of the jury. The defense appears to be assuming the jury to be basically the potential jury pool and trying to avoid the potential taint to a jury pool that discussion of evidence, which may or may not be admissible, may cause. I think that's a fair point. I just want to put the court on notice of our view and how we have and intend to proceed as we move forward. Under 104B, that determination takes place outside of the presence of the jury. Under the rules, there's a presumption that these hearings and this hearing is open to the public, including admissibility hearings. Because of that, we intend to move forward and move the admission of evidence and argue the admission of evidence as in open court. Should the court close the hearing, of course, that would change. But that's because that's the presumption in the law, and that's conforms with 104B. That's our intention, unless the court or counsel moves to close the hearing. So, in summary, the court can and often should consider evidence and review the exhibits before admission. 2, the court is not tainted by doing so and can distinguish between admissible evidence and improper evidence. And there's no need for the court to identify which hat it's wearing. And 3, absent closure, we'll move forward with our evidence in open court.
All right. Well, I'll hear from defense if you want to be heard on that issue. I see you. Okay.
Briefly, Your Honor, I'm sorry I have 2 microphones. I'm just trying to be technologically savvy. I think the 104 issue, I agree completely with Mr. McBride on what he's saying. Because of the Supreme Court's ruling in Archuleta concerning the availability to the public of exhibits from a preliminary hearing, which of course is a fact-specific inquiry by this court, we will continue to raise concerns about our client's right to a fair trial when we think it's appropriate, and the court will make the rulings it makes. That's all I want to say.
All right.
All right. Shots fired.
All right, to both parties, the standing request remains when you are moving a piece of evidence into to the record, I ask 3 steps. Admissibility, to admit it, to be published in the courtroom, and then to be published on that screen. And I'm going to have the screen adjusted slightly because if it's published, I want it to be meaningfully able to be viewed. And I noticed somebody sent me a screenshot that angle creates an interesting angle that kind of distorts it. So in the interest of, if we're going to be transparent, it should be viewable transparent. So
thank you, Your Honor.
We'll adjust that screen
I can fix it, but still.
Briefly, but please address those three issues. And I understand one side or the other might say, well, we agree or we don't agree, period. But please, I'm trying to make sure that the record before us is a clean and clear record. So if you would do that, the court would appreciate that. All right. Anything further?
No, Your Honor.
All right. The court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. I will leave it to the parties to monitor the courtroom to ensure that compliance is adhered to. With that, turning to the state, you may call your next witness.
Or call
Yes,
the
I mean,
last
I want
witness.
the press to be able to see it too, but when there is a bit of a distortion when it's at that particular angle. So
The judge is
while
watching.
the parties are moving forward, go ahead and adjust it, and let's put a sample image of something that has nothing to do with this case on the screen.
How about a picture of your latest fishing trip, Your Honor?
I don't know that it is projecting yet. And I don't know if we need to take a break to make sure that's working.
Is it not
Another-
projecting on the
another tech
monitors?
issue? We're seeing Zoom.
Okay. Technology is challenging us again. Well, what's our thought, staff, on projecting? Is this something that's not going to be cured by turning off and turning on, I'm assuming?
It's a source issue, Your Honor.
All right, if you, all of you, council table, again, I'm trying to do this to get this out of the way so we can move forward cleanly. If you wouldn't mind turning off your monitor and then turning it back on, and
also sprinkle some
if I
pixie
could
dust
borrow
and
somebody
wish
to do
really
that
hard.
to the witness monitor as well, so we all get them in sync. Thank you, sir. I appreciate that. And for the lectrum as well, let's just see if we can get that up, because that could cause a delay. I just want to knock this out first. Yes.
Judge is asking everyone at their own tables to see if they can get it up on their monitors. And just look for the
Where
camera.
would that TV go?
Can we put it back where it normally goes?
If that
Your Honor?
doesn't address any security issues, let's do that. I just want to make it easy. That way that TV can be more flat and it's not a distorted view, and then the media can look at that TV. Again, transparency needs to be viewable, not just there in concept. All right, yeah, let's go ahead and do that. How are the monitors looking? Nothing? All right.
Now we need to take a tech break.
I see. Could I have someone with your laptop plug in so we can test, so we can check if it's receiving the data or the information from your laptop to allow us to project? That may be the issue.
Mr. Ellis is plugged in.
All right. Let's take
If you want a good job, pays well, doesn't require much work, but does have a little bit of high stress at various times.
I appreciate the parties'
Go apply to court
patience,
as a tech guy.
especially after I just said we're at the
Working?
halfway point.
We're getting a thumbs up.
All right, so it's displaying for defense, for prosecution.
We're working on it right now, Judge.
There's we're off. Okay.
All right, and on the screen monitor here, it looks like something came up.
It's blue.
All right, we'll just hope that the monitor for the witness works as well. All right, so we're ready to go? Just bring it in and go ahead and we'll get started. And how much time is needed for that?
2 minutes.
Well, let's go ahead and proceed, and then when we take a break, then we can do that. But for now, the media, if you can see that TV, if you have any problems, please let me know. And we're going to bring in that second TV. We just want to get the train on the track here. All right, Ms. Hunt.
The state calls Agent Brian Davis.
Brian Davis.
Agent
next.
Davis, if you would like to come forward and be sworn in.
So
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
he's going to be most
All
of the day on the
Agent,
stand,
if
and then
you
we're
wouldn't
going to go
mind
back
having a
to the
seat
last
to your left is a water bottle.
witness. But the
And
state
after you're
still-
seated,
defense
you'll
still
have to
hasn't
address that
crossed.
microphone, pull it down, and then pull it toward you to ensure that it is picking up your voice, and we have a good record. All right. Ms. Hunt, your witness.
If you could please state your name and spell your last for the record.
Yeah, it's Brian Davis, Davis.
What is your occupation?
I'm an agent with the Utah State Bureau of Investigation.
How long have you been with, is it fair to call that SBI?
Correct, yes.
How long have you been with the SBI?
Total 18 years.
I want to briefly go over your experience as a law enforcement officer generally. Actually, are you a law enforcement officer in that capacity?
Yes, correct.
How long have you been a law enforcement officer?
Total of 27 years.
You mentioned you were with SBI for 18, is that right?
Correct, yep.
What other agencies were you with prior to SBI?
So Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with Utah Transit Authority Police.
We've heard talk from other officers about POST. What is POST?
It's Peace Officer Standards and Training.
Did you complete that?
I did.
What year did you complete that?
1999.
Is that a type of certification that you hold?
Yeah, it's a statewide certification that any peace officer in the state of Utah, local, state, county, all go through to become a certified peace or police officer.
Has that certification lapsed or been any gaps in that time since you received it in 1999?
Nope, it's been constant since then.
I want to talk about a bit about your training and experience within law enforcement. What roles have you had at SBI?
I began as a call enforcement team. We did covert and overt operations. I was assigned to an ATF, the PSN task force, focusing on violent felons with guns and drugs. I was on a FBI task force, Safe Streets. It was a gang violent crime task force. I was on the U.S. Marshals Fugitive Apprehension Team task force. I've been on several different OICI protocol teams, Officer Involved Critical Incident teams around the state of Utah and within SBI. I've been on dozens of those scenes. And within major crimes of SBI, I've been, we've worked a variety of cases. I work anything from violent crime, homicides, sex crimes, drug crimes, firearm crimes, white-collar crime, fraud. I was also on a task force with a FBI public corruptions task force as well.
Was that all on-the-job training, or did you receive specific training or conferences, things like that?
Yeah, throughout the years, various trainings, conferences for in all those capacities over the years.
You mentioned you've been a part of homicide investigations.
Yes.
Can you estimate how many?
My best guess would be 60 plus, where I've had some involvement. I also currently work on a cold case unit within SBI, so we consult with agencies around the state of Utah, and I've probably consulted on over 50 of those as well in various capacities and roles.
Have you received training specific to homicide investigations?
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation. I'm a FARO certified. It's a 3D FARO scan of crime scenes.
What's a FARO scan?
It's a 3D laser imaging that's used pretty commonly on crime scenes. It just accurately documents crime scenes. And I've been on, I'm been certified as a forensic interview and the forensic interview technique with more child victims. So just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI?
Correct.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for it. Ultimately, you direct the case as you go along. You make assignments as needed. Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen that case, if applicable, to the appropriate county attorney or DA.
You mentioned that you are a co-case agent or were with Agent Hull. Is it typical to have 2 case agents on a case?
It can be especially on a large case, yes.
Has this particular case been large?
Yes, it has.
Have other police agencies been involved in the investigation of this case?
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency.
I know there are probably several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Orem Police, Utah County Sheriff, Washington County Sheriff, St. George PD, most of all the agencies within Utah County and even others outside of the county. So we've worked with a lot of agencies with this case. It was a pretty large scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
All right. I know a lot about so as a case agent, have you been in court during this preliminary hearing?
Yes.
You've heard prior testimony?
Yes.
We've talked a lot about the events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. That evening, it was about 8:30 p.m., I believe, of the 11th. I received a phone call from Sergeant Elsholz requesting that I travel to St. George.
Who is Sergeant Elsholz? What agency is Sergeant Elsholz with?
With SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual was turning himself in, or was going to turn himself in to police in regard to his involvement with the incident, the shooting on UVU campus.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m.
Did you travel down to St. George?
I did.
On what day?
Of September 11th.
Did anyone else go with you?
Yes, so we traveled to the Salt Lake City airport to a hangar there, and we were flown down on a fixed-wing aircraft. It was Sergeant Elsholz, was Agent Folger with FBI, Agent Anderson with FBI, Ryan McBride and myself, and the 2 pilots.
And who is Ryan McBride?
With the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30 p.m. at the St. George Airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground to the Washington County Sheriff's Department.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
Oh, we did.
You did?
We did, yeah.
What other agencies?
Well, with FBI as we were traveling, and then along with mainly the Washington County Sheriff's Department, we also have agents with an SBI assigned to the southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office?
Yes.
What time did you arrive there?
Probably somewhere close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
You mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio video recording device, and so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
And was he with anybody else?
He had been, he'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them. How did that happen? Who was spoken to first of the other individuals?
So Tyler's mother was interviewed by SBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by SBI agent Terry and FBI agent Smith. And also at that time, the family friend Mike Mitchell was interviewed by other agents as well.
And you said that these interviews were being conducted simultaneously?
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes, myself and Agent Folger. Did I misspeak earlier? Myself and Agent Folger interviewed the mother.
All right, let's make sure the record's clear on that. So Agent Folger, what agency is he with?
With FBI.
And yourself interviewed Tyler's mother?
Yes, that's correct.
I just want to make sure the record's clear. Who interviewed Tyler's father?
Yeah, I think I might have misspoke. It was Agent Holgreen, Agent Cox that met with his father.
And then who spoke with family friend Mike Mitchell?
Agent Terry, Agent Smith.
Family friend. I
Down
think
in
that's the Scoutmaster.
St. George, Washington County Sheriff's Office, was Mr. Robinson detained at that time?
Yes, he was.
Was he formally arrested at that time?
Yeah, after all the interviews were completed, when we talked to everybody, he was formally arrested at that time.
And I'm going to come back to that in a second.
Talk to everybody?
Well, excuse me.
Including him?
Where did the arrest take place?
At the Washington County Sheriff's Office.
And what date did that happen on?
Would have been September 12th. It was about 4 a.m., I believe, of September 12th.
All right, I want to show just on your screen, not for public yet, what's been marked for identification as State's Exhibit 15. Let me know when you're able to see that.
Okay, it's there.
Before I ask you about that, did you have an opportunity to, you stated that you observed Mr. Robinson at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, could I have a moment with Ms. Hunt? May I have a moment with Ms. Hunt?
You may.
redacted version.
And that may happen a couple more times as we go through exhibits
I
because
understand.
of agreements and disagreements that we have.
Thank you for the heads up.
At Washington County Sheriff's Office, where you initially observed Mr. Robinson, you stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Is that standard practice for a facility like that to have video recording in such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict Mr. Robinson at that time?
It does.
You see on your screen what's been marked as State's Exhibit 15. Do you recognize that?
I do.
What is that?
That's the interview in which Mr. Robinson was seated and waiting.
Ooh. If we get to see this, this is all new. We did not know if he spoke at all.
State moves
the
to
police.
admit Exhibit 15.
Ms. Hunt, and the other two steps, what's your request?
We would ask to admit it into evidence. We have, defense counsel and I have agreed upon, I guess, redaction of the video, and I would ask to publish it both to the courtroom and to the media.
Mr. Novak?
It's silent, correct? Ms. Hunt?
Yes.
Yes, Your Honor, Ms. Hunt is correct.
It's
the
silent.
state had originally proposed a longer image with audio, and we've agreed to a shorter image without audio. And so
That's correct. Yeah.
So we're fine with all three steps as to this exhibit.
Okay,
All
we
right.
get to see
Does
it.
the state wish to review this to make sure that what's queued up comports with what you believe? If not, we can move forward. I just want to allow all parties the opportunity to double check.
Let me just confer with my paralegal.
Paralegal carrying a little weight here. They did turn Tyler Robinson's screen off. Maybe he doesn't want to see himself.
Oh, that's probably right.
I think he turned the screen off when they were showing the video of him running across the roof as well. I might have to go back and check that, but I think when they showed the security camera footage from yesterday.
It has no audio, so we would like to admit and publish it at this time.
All right, State's Exhibit 15 is admitted pursuant to discussion and may be published in the courtroom and may be recorded or transmitted electronically.
And Your Honor, of course, this is subject to all of the objections which have been previously reserved in writing and reiterated over the
TV's now
last
behind
couple of
a pillar.
days. I assume that we don't need to start over with that today.
Thank you. I appreciate that. I note the standing objection by defense as previously made, and that objection is overruled, and this exhibit is admitted.
And in this case, it wouldn't be the 1102 issues, it would be the electronic media coverage of the proceeding.
Thank you for that clarification, Mr. Novak. I appreciate that. All right, with that, to the media, can you view that screen okay?
No.
All right.
Say no.
All right.
No.
The State's Exhibit 15 may be played.
And Agent Davis, who are we seeing here?
That's Tyler Robinson.
And although we are watching it on video, what is he wearing at this time?
He's working a dark colored baseball cap with has like I believe it's like maybe the Hurley symbol on it, like a white symbol on front. It's a burgundy short sleeve shirt with no graphics. It's blue jeans and gray and white tennis shoes, leather Converse style tennis shoes.
Thank you. Was Mr. Robinson, you stated that he was arrested in the early hours of September 12th, is that right?
Yes, that's correct.
Did he remain in Washington County Sheriff's Office, or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
Prior to being transported to the Utah County Jail, was any, I guess, personal property taken from him, clothing, anything like that?
The only thing that was, so prior to like our arriving to the St. George, to the Washington County Sheriff's Office, his cell phone was seized and taken from his person. But that was the only thing that was taken from at that time.
After he was transported to Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
And sorry, you may have already stated when did he arrive in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individuals personal identification of the charges, the probable cause statement, and then it's signed and submitted to the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case. As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famuina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning, and then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you've stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Are you aware of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
Here we go.
And we won't get too into it right now. We'll cover this with Sergeant Faumina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
All right, turning to another area. As part of this investigation, you have previously mentioned that a family friend came in initially with the Robinsons. Who was that family friend?
His name was Mike Mitchell.
And who is he in relation to the Robinsons?
So he's a family friend, a good family friend.
And what was his involvement here?
So he helped facilitate working with Tyler and his parents with the Sheriff's Department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell?
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
That one was Agent Terry and Agent Smith.
What agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
It was Ryan McBride, Chad Grunander, Kimberly Derfler, and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Derfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry?
Yes.
So you were not present for this collection of this statement?
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell at it was the St. George, well, it was at the St. George courthouse there. They met and discussed briefly. I was going to kind of talk generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour where he hand wrote a statement, filled the statement out.
For an hour?
When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. It sounds like there's an official form that is used. What's present on that form, if you know?
There's an admonition or warning given on those forms that states that the information you're giving is true and accurate to the best of your knowledge, that any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down?
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation, objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained?
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
We think Mike Mitchell retired in 2024 from the Washington County Sheriff's Office after 24 years.
For identification as States Exhibit 14.1. Let me know when you see that on your screen.
So family friend, law enforcement, scoutmaster.
Okay, I see it.
What is that?
This is the written 1102 statement that was provided by Mr. Mike Mitchell.
Your Honor, may I have a minute with Ms. Hunt for the same purpose?
What if Ms. Hunt doesn't want to have a minute with you?
All right.
And how do you know that?
I reviewed it. I reviewed it in its original. As soon as it came to us, I've seen it prior. So.
And Kimberly, if I can have you slowly scroll down.
Mike Mitchell retired on January 11th, 2024, after 24 years in Washington County as the Sheriff's Office. Started in the jail back in 1999. Ended as a detective.
Sorry, Judge, if I can just have a moment.
You may.
Paralegal getting some hurried instructions here. She's the one that's putting the exhibit up on the screen. I think Mike Mitchell, if he's the right guy, if we've got the right picture here. Let's see if I can show this here. I think this might be him right here.
I apologize, Your Honor. I misspoke. It's not 14.1. It's just
the guy on the right.
Exhibit 14.
Okay.
So if we can place that again on the screen for the witness only. Yes. And sorry, we had been scrolling through that. Do you recognize that?
I do.
Does it depict, is it fair and accurate from what you remember?
Yeah, with the exception of the redactions, yes, it's fair and accurate.
And Judge, I'll make a record. Defense counsel and I have stipulated on the redactions that are present. I would move for its admission. State's Exhibit 14 into evidence, but we do not wish to publish it either to the courtroom gallery or the cameras.
All right, could I have a copy of it? What I have is the unredacted version. So I want to review it before I make that decision.
So this statement by the family friend that helped negotiate or facilitate Mr. Robinson turning himself into the police, he wrote for an hour. What is it? They said 22 pages? Is that right? I don't know. Maybe it's a different one. He wrote for an hour. He wrote this story, his version, what went on.
Thank you.
The state saying, we're going to keep this card unturned at this point as far as the public goes. We're not going to show what we have in our hand. I imagine it's some compelling evidence that is probably pretty bad for Mr. Robinson. Maybe in the line of confession or something along those lines. The judge reads the redacted copy. Just quickly scanning the pages. This is something that would be made public at the trial, but not at the preliminary. I can't imagine that Mr. Mitchell would have too much to say about.
I've had a chance to review State's Exhibit 14.
Anything too graphic.
And noting the standing objections by defense concerning 1102s, the court accepts into evidence State's Exhibit 14 and pursuant to the parties is not published.
Thank you, Judge.
I don't like that.
All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about that bullet, what that is about?
Yes, I do.
What roof was that bullet found on?
I believe it was found on the computer science building, on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes, yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is, it's a building directly kind of south and east of there, from the LOSI.
Southeast from the LOSI building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ben Schneider, there was not a line of sight from there to where the tent was, where Mr. Kirk was.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
Yeah.
What is a live round?
It's a round that had not been fired, so it still had the projectile, and it was a fully functional bullet with ammunition with the bullet.
Did you learn if this .223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been it was not dented. That when fired, it still had the bullet projectile in the end and still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider.
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections about this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. You've mentioned him already. Are you familiar with an individual named Lance Twiggs?
Yes, I am.
And who is he in regards to this investigation?
He's the roommate of Tyler Robinson.
Was he interviewed as part of this investigation?
He was.
How many times?
2 times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD?
Correct.
Do you know who was present for that interview?
It was FBI agents Larson and Agent Ling.
Are you aware of Mr. Twiggs' buccal swab was taken at that time?
I don't recall happening there. I believe it happened later. I'd have to, but it did occur. That was obtained from him.
Okay. But you're not sure if it happened on the 12th?
I don't recall if it was there or later at his residence.
But ultimately, a buccal swab was obtained from Mr. Twiggs?
Yes, it was.
Do you know if his phone was taken from him?
It was.
When did that happen?
So it was during that interview with FBI at St. George Police Department. They conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
You mentioned a second interview of Mr. Twiggs?
There was a second interview, yes.
When did that take place?
April 20th of this year.
Where was that?
Ooh, just recently.
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
It was Mr. Twiggs with his attorney, Jill Cottrell. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schulz, well now it's Lieutenant L. Schulz, and myself.
We've talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before Mr. Twiggs' interview on April 20th, 2026, well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
It's a letter of the use of immunity is essentially giving the individual, during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident.
They can't
but it does not preclude them from prosecution from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Greeners, congratulations. So excited.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
We've talked about 1102
She's a cutie.
Statements. We've talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
Yes, that's correct.
Was a similar admonition given to Mr. Twiggs during his second, or before his second interview on April 20th, 2026?
Yes, it was.
By whom?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview?
I was.
Did Mr. Twiggs say that he understood that admonition?
He did, yep. Yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge, I'm aware that defense counsel has objections
Here we
to
go.
this recorded 1102. I think now is probably a good time to
have that
address
fight.
them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first, and if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot.
Yes.
So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but and if you want to move it, because right now nothing's before me.
Yes.
Move for the admission.
Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proffer. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel. They have acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. Monday at about 4 p.m., defense counsel sent us a transcript that was prepared by the defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it. In total, redactions appear on 16 of the 21 pages.
Whoa.
My procedural objections to this are that this is essentially by surprise. We were already a day into the preliminary hearing. Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue as it relates to Mr. Twiggs. At that time, they did not raise any objections to the substance of it or propose any redactions that they wished. And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing.
Objection
it's not
by ambush.
I did mention that defense prepared a transcript of this recorded interview, how the state intended to present it, and how we have given it in discovery to defense is it's a video, audio and visual. Making redactions to that is not as simple as a transcript where you can just, block out sections of the text. So it's far more complicated than that to edit or redact portions of the video at this time. So we would object procedurally, basically on the timeliness of it, that they had an opportunity to make these objections if they had them at the time when the 1102 issue in regards to Lance Twiggs was briefed and decided by Your Honor. They did not do that or raise the issue at this time. And so we would object just procedurally on those grounds.
It's time to get the speed editor out.
Additionally, the remedy requested, which I'm assuming is that we make redactions to the video or present it as a transcript rather than a video, is disproportionate. Even assuming if there are isolated statements that the court would not ultimately consider, again, as Mr. McBride pointed out, and as Your Honor has stated throughout this hearing, this is a preliminary hearing to the court. It's not to the jury. The court is fully capable of disregarding any statement it determines exceeds the proper scope. As Mr. McBride cited this morning, several cases give Your Honor that authority and presumption that judges are able to basically make the difference between what's admissible evidence and disregard what may not be at a preliminary hearing or even at a bench trial.
The state's saying they
State
want
v.
to play it
Adams
all.
is one of those cases. If Your Honor wants the citation, again, I'm happy to give it. State v. Featherson is another one. That one is 781 P2D 424. State v. Hannigan is another one, 2014 UT App 165. And State v. Rosecrans, 2024 UT App 128. And those cases all stand for the notion that essentially judges, and this is to quote from Rosecrans, judges are not subject to many of the same concerns about prejudices and improper influences as jurors. And so, again, procedurally, the remedy, asking us to now, in the middle of a week-long preliminary hearing of which everyone was aware, edit or alter or redact portions of this video recording 1102, that remedy is disproportionate. If there are any potentially objectionable statements within that, Your Honor has the ability to disregard those. And so we would prefer not to get into the substance and argue each statement line by line. And we would prefer to just move for its admission and have the court use its discretion as a judge to take what's proper versus improper, disregard anything the court might find improper.
He's not worried about himself.
If we
He's
would
worried
like
about the
to
potential
move into
jury.
substantive objections, then we're happy to, but if the court can rule on those procedural objections first, it may make any substantive objections moot.
Yeah, say basically your
So
objections
you're moving
aren't
into evidence
timely.
State's Exhibit 16?
Yes.
Yes.
And as it relates to publication, what is your request?
So, Judge, we believe, I believe this has been discussed before on the record,
1102 is a public
that
document.
the state is in agreement that the media should not have the ability to handle or replicate certain exhibits. Because it's video, Mr. Twiggs is shown certain exhibits. So we would agree that this should not be captured by cameras and projected by the media outside of the courtroom. But we would like at least the audio and maybe even the video within the courtroom itself to be captured, is the state's position.
All right, I want to make sure I understand. So your request is that the video not be projected and captured by the video camera, but the video and audio is played in the courtroom and the audio is able to be transmitted, just not the video via the camera. Is that my understanding?
Correct, that's the state's position.
All right. And
Audio's better than nothing, but this, I don't like that.
in regards to this exhibit, is in the, as State's Exhibit 16, is there any portion of that recorded statement that occurred before the
Miranda? What? Limited use?
the 1102 warning was given to Mr. Twiggs?
Not that we are presenting today.
Okay. All right, turning to the defense, Mr. Novak.
Thank you. Thank you, Ms. Hunt.
Okay, here
So
they're
I'm
going to
going
fight
to address
hard.
first, Your Honor, what Ms. Hunt describes as the procedural issues with our proposed redactions. Many weeks ago, the state lodged their anticipated exhibits with the court.
So Novak stands up and says,
And
"Once
then the
upon a
court
time."
said, I'm not going to review them. In fact, I'm returning them. I'm sorry. The court said that the court is returning the exhibits to the state. So there is no moment to make objections to an exhibit which the court is not inclined to entertain until the moment, as the court has said many times, until the exhibit is presented. And so what we have done is we have given the state, it's only a 20-page transcript, excuse me, it's only a 20-page transcript.
What would we throw on the ground?
We have given the state a transcript we prepared.
The transcripts, all his notes.
Ahead of time, so that the state could make sure that the transcript is accurate.
Ms. Nestor did that as well
The
yesterday.
state has never said that the transcript is inaccurate, so I'm going to assume for purposes of the moment that the state doesn't have any dispute that the transcript is an accurate transcription of Mr. Twiggs' recorded 1102 interview. There's no surprise here. There's been all of Monday evening, all of Tuesday, this morning. In fact, the state informed me yesterday morning that they don't agree to the redactions. So there's no surprise here. And we're actually doing exactly what the court signaled should be done, which is at the time an exhibit is proffered, objections shall be made.
That's what he said he'd do. He's right.
This wouldn't be as much of a problem if Ms. Hunt had just said to Your Honor, following Archuleta, and in light of the electronic coverage of this proceeding, and in light of Mr. Robinson's right to a fair trial, the court will consider those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible, but it will not be broadcast either audio or video. So that becomes a problem because the categories of objections that we have to this video recording, I'm going to talk about a little bit so that the court understands why Ms. Hunt's suggestion that the entirety of an exhibit, which may not be admissible under the rules of evidence at a preliminary hearing, be played in open court, and that the audio be captured by electronic media and broadcast. Because of our client's right to a fair trial, that's a problem.
That was
and I don't want to sound flippant, but this is actually the Ryan McBride 1102. The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single statement by Mr. Twiggs is just an affirmation of what Mr. McBride says, but the vast majority of it is. There are also portions of this 1102 where Mr. McBride is basically testifying as to what other exhibits that this court will see say. So there are two other exhibits that this court will be asked to receive into evidence today, which are text messages and a group chat. I'm just going to distinguish between the two. And so this 1102 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying as to what the exhibits say. So in some ways, the 1102, those portions of the 1102 violate the best evidence rule, because I have no doubt that those two things that I just talked about are going to be presented to the court by the state. There are also portions of this 1102 which are not relevant and really implicate Mr. Twiggs' privacy rights. And I am not Mr. Twiggs' counsel. As Ms. Hunt said, he has counsel. I don't know if he's, well, I don't want to speculate.
Ms. Cottrell's his counsel.
But it's not relevant. There are portions of it which are not relevant, and there are portions of it which I think, especially to be broadcast, implicate other privacy interests. So I'm not trying to create complications, and I'm definitely not trying to take the state by surprise, because I went to great lengths to provide the state with a transcript, with a proposed redacted transcript. And in fact, today, we prepared to make it easier on the state and actually on Your Honor. Instead of having redactions with big black sections, we highlighted them instead. So if the court wants to look at our proposed redactions, the court can do that without having to compare two documents.
We've highlighted the parts we
The
don't
other thing I
need to
want to
see.
say is that if the court did order ultimately that portions of it would be broadcast in any way, in the courtroom, outside the courtroom, we're not trying to change the state's exhibit from a video with audio to a transcript. The transcript is really being used as a tool to address the inadmissible portions of the video, because there's no way to communicate to the court efficiently which portions of a video we think are not admissible. It's much easier to do it on paper. So the transcript is just a tool. We have the ability right here in this courthouse to cut the video into the pieces that the court deems admissible. Mr. Ellis tells me it would probably take a couple hours at the most. So maybe
couple hours.
Maybe
Day.
that's also not a concern. There's no delay associated with this in light of the fact that it's Wednesday and this court is going to conclude this hearing by Friday afternoon. So I've gone beyond the procedural issues. I've addressed that we think portions of it are not admissible. There's no surprise. We've followed exactly what the court has signaled, which is I don't want to hear about exhibits until we're in the middle of the hearing, and I don't want to hear objections about it till we're in the middle of the hearing. The litigation over whether Section 1102 is constitutional under Mr. Robinson's federal due process rights and the other rights that were addressed, that litigation does not mean that we should have brought to the court proposed redactions to an exhibit in a hearing which hasn't started yet, in a hearing in which the state hadn't, until 20 minutes ago, even proffered an exhibit. So I understand that the state wants to avoid the substance by trying to short circuit this with a procedural argument. And Ms. Hunt is a very excellent advocate for her client. But the reason why the state is going to the procedural issue is because the state, because the exhibit contains significant content that is not admissible even in a preliminary hearing. So I'm going to stop now, but I do want to go back and say that if the court concluded that only Your Honor was going to review this exhibit and the Archuleta rule would be extended to this exhibit, including that it's not going to be broadcast, then I think that we have a different path toward the efficient resolution of this issue.
All right.
Does that make sense, Your Honor?
I believe I understand what you're saying. So let me respond to you before I go to Ms. Hunt. So going to your first point in regards to what this court's position in not looking at the exhibits, that doesn't preclude any party from filing a motion in limine, which is anticipated before anything is moved into evidence. Typically, motions in limine are used by either side on anticipated exhibits or that may come into court, and that allows pre-litigation. So I want to clarify that the court statement, like I'm not looking at the exhibits, is far different than what the parties choose to do and file in regards to a motion in limine. But going to I really want to go to what you've talked about. What specific objections are you making? I want to make sure the request is clear so I can rule specifically on that. What exactly, I think I understand some of them, but I wish for you to articulate what are your objections to State's Exhibit 16.
Well, it's right to a fair trial.
We could do it line by line or page by page. I know we have had hearings in this matter where the court has wanted to look at transcripts line by line, word by word. We're prepared to do that. But I'm going to give the court categories.
Thank you.
Without referring to specific portions. There are many portions of it which are not the statement of Mr. Twiggs. They're Mr. McBride testifying on video as to what other exhibits say. And Mr. Twigg is saying, yeah, that's what it says. Yeah, that's what it says. Yeah, that's what it says.
So I apologize. I don't mean to interrupt you. I
no,
just
it's fine.
want
It's
to
objection
categorize it and put it in a box. So what is the what objection under the rules of evidence is that specifically? What are you boxing that as?
Well, first of all, it's counsel testifying. Second of all, it's hearsay. It's Mr. McBride's out-of-court statements as to what an exhibit says. There's a best evidence rule, which I'm sure the court is familiar with, which is that the best evidence of what an exhibit says is the exhibit. So we may have a little bit of a cart before the horse here,
sure,
because there are two exhibits that I'm very confident are coming. There are portions which are not relevant.
Relevance.
There are portions which I believe are inadmissible when the court balances under 403 the probative value versus the prejudicial value, especially in light of the manner in which this hearing is being broadcast. So we have improper testimony by counsel. We have the best evidence rule, which I think also includes hearsay. We have relevance issues, and we have 403 issues. And so, but what I'm saying is that those are all things that this court can manage, as Ms. Hunt and Mr. Bride have taught us today, in terms of the court's preliminary assessments, the court's role as a magistrate, and the Archuleta rules that allow this court to decide certain exhibits will not be viewed or heard by the public because it interferes with Mr. Robinson's right to a fair trial.
Constitutional violation.
And I heard exactly what the court said about the in limine situation, but I do want to just say this, and I hope this is taken in the right spirit. If this court had said to us, I'm returning the exhibits, but if any party has any objections to any exhibits, I want to hear about that before the hearing, we certainly would have done so. And I think that
you're blaming the judge.
It's probably, for counsel, a suggestion about how future hearings where there are many or complex exhibits, because there will be such hearings, should be handled, which is we can do in limines before the hearing begins, so that the court knows these exhibits there are no disputes, these exhibits there are disputes, these are the disputes, and we don't have to waste courtroom time bringing the court up to speed on what those concerns are. It can all be briefed ahead of time. And we're happy to do that.
Didn't provide any specifics.
Going to the last point, let me be clear on the record that I don't intend to interfere with the duties of either party. It is not my job to say, well, here's what you should do, here's what you shouldn't do. I'm independent. I'm not team prosecution, team defense. And so I will not dictate how you run your case. Obviously, if it goes against certain rules, constitutional rights, statutes, case law, I will weigh in, but I never want to put my finger on and say, well, Mr. Novak, here's what I think you should do, or to the state, Mr. McBride, here's what I think you should do. That goes outside my role, and I will not deviate from my role, which is not to interfere with the business of counsel. And I'm fortunate as a district court judge that I have very experienced attorneys who I have watched and have done an excellent job. And your experience, as I stated on I believe in the Pro Hoc Vice, highly experienced attorneys on defense, highly experienced attorneys on prosecution. And so I do not want to get into the business of saying, here's what you should do. I hear what you're saying, but I want to be clear from this point on, in case there's any ambiguity, the court does not need to go into the business of dictating what you feel is in the best interest of your client to the state what is in the best interest of your client. I staying clear of that, but I appreciate the point you're making, and I hope that clarifies any ambiguity that may exist.
There was no ambiguity. I don't think that what I was conceptualizing puts the court's finger on anybody's scales. I think it's really about case management. And now I think we're moving pretty far away from the admissibility of this 1102 statement, and we could have a conversation later if the court wants to. It's up to the court about case management issues. But
careful there, Counselor.
As I said before, if I say anything else, I'm going to be repeating myself. So I'm just going to stop.
All right. Thank you, Mr. Novak. Appreciate your thoughts. Ms. Hunt.
Yes, thank you, Judge. And as I tried to parse out, obviously we have procedural objections, which may, depending on how the court rules, make the substantive objections moot or unnecessary. But to Mr. Novak's point about this not being by surprise, yes, to be fair, he did send me a transcript with proposed redactions Monday, I believe at about 4 p.m. It was not accompanied by any objections that he actually had. So we had to compare the transcripts and, to our best guess, come up with what the substantive objections may be. I am ready to respond to what I believe they may be, and obviously he's now given categories. But I think we're now at the point where the court needs to exercise its ability and obligation under Rule 104A to decide a preliminary question about whether evidence is admissible. But before we do that, because to argue the substantive objections, I want to actually get into the substance of it. And so I think we need to consider whether this is going to be a closed hearing, and then probably, I don't know, I'm assuming the media attorneys will want to weigh into that, because I do want to quote specific sections to be able to advocate for my position, the state's position on this. I think we will need to get into the meat of what is actually stated here. And so I think the court needs to decide if this is going to be an open or a closed hearing, and hear from the media or any other parties that need to weigh in on that.
All right. Anything further from the parties as it relates to that?
Only that Ms. Hunt invited the media to comment on what the court is going to do. And as Your Honor knows from conducting jury trials and other types of proceedings, sidebars are not for the public. They're not for the public in real time, and they're not for the public subsequently. It is very standard that sidebar proceedings where information is only to be exchanged between counsel for the parties and the court are conducted at sidebar so that witnesses, jurors, members of the public don't hear about those things. And so we are assuming that if the court wants to do this in what we would call sidebar or in a closed hearing, that the transcript of that is going to remain at least temporarily sealed until these proceedings conclude or the court conducts some closure analysis on a topic by topic basis. So that's what sidebars are about, whether it's done in a closed hearing or in an open hearing through whisper. The public, potential witnesses, jurors, potential jurors don't get to hear what the court decides needs to be addressed in a manner which protects the parties' rights.
All right.
Media? Here we go. Thank you, sir.
Your Honor, if I may, Michael Judd on behalf of the media. A request to close a court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a hearing requires that the court engage in some sort of hearing about that closure that is open to the public. It can't be done in whisper. That can't be done with the cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors. But the conversation about whether or not that happens, of course, has to take place in public. I don't want to belabor any of the points that are made. I think the court recognizes the interests at issue here and what the media's position would likely be on these. I'd like to find common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview that is at issue here is very important. And that, of course, makes people want to invoke protections, invoke closures. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing, there may be exhibits that do not present significant pillars of support for the decision that the court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me, I haven't seen this video, the public hasn't seen this video, it seems to me that this appears to likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision will likely rest. That counsels in favor of access, in favor of publication, in favor of allowing the public to see the work that the court is doing and why it's doing it. I recognize Archuleta has been invoked. We respect and understand Archuleta. Respectfully, Archuleta, at least part of its reasoning is based on something very different than putting something on a screen. In Archuleta, there was a request to say, hey, is there a murder weapon? Are there crime scene photos? Can we come handle those, right? Can we look at them? Can we turn them over in our hands? And part of the reasoning in Archuleta was we're worried about that will impact the quality of the evidence and the obligation everybody has to keep that evidence reliable and safe. Putting something on the screen doesn't present any of those sorts of risks. Because this is so important, so this interview appears to be such a critical piece of the case being presented here in this courtroom today. The media's position is that it should be shown on the screen and that the public should be allowed to see it as well. To the extent there's any sort of compromise at all, the one that is presented by the state, which would allow the public to monitor and oversee and understand and comprehend and assist with the work being done by the court, then something like the state has provided, which is we allow the audio to play. If there is some sort of, it sounds to me like what the state is saying is there's some sort of witness privacy issue that would be served by turning that video off. Maximalist advocates on behalf of the media would always want that video to be on, but I recognize that that may be a reasonable compromise. But the idea of shutting the courtroom down to argue about closure or keeping this recording from the people in the courtroom who are allowed here, the victim representatives, the media representatives, the public itself, is simply a non-starter, I believe, under the rules that govern this proceeding. We ask the court to keep this as open as possible, and if there is any sort of narrowing of the public's right of access here, that it be done only in the narrowest way possible, and that it be based only upon recognized interests. And finally, I would say, Your Honor, to the extent that I hear any sort of real counter interest at all, it continues to be a fair trial interest. We take that important. We recognize that its importance, we take it seriously. The court has also over and over again recognized what the right approach to that is to say there are mechanisms in place under Algier to say we do an expanded voir dire, we do a jury questionnaire. We can handle those counter interests, and on behalf of the media and the public, I'd ask that the court handle this dispute that way.
Thank you.
Thank you,
Any
sir.
further comment by any of the parties?
I think the media might have to file an appeal.
Only that I want to make an additional assertion about why the court should handle this exhibit pursuant to Archuleta, but I want to make that argument at sidebar, because the whole point is to protect my client's right to a fair trial, and by making part of this argument in open court, it's a self-defeating exercise. So when the court resolves whether it will hear from us at sidebar, we're prepared to do that.
All right. The issue is sidebar is public because the transcript's open. So it's just because the parties request sidebar and the court invokes the white noise, that doesn't make it private. It simply obscures the noise in the courtroom because that goes in the transcript unless it's a closed hearing. So
we would like to have a very brief closed hearing to lodge another objection about the publication of this, of any portion of this exhibit, of certain portions of this exhibit beyond Your Honor's eyes. That's what I'm saying.
Thank you. All right. Right now, what we're going to go ahead and do, and what I want to do is I want to look at the redactions that you're proposing. And take a look at that. And it's also a perfect time to take a break because we need to bring in the monitor potentially for future exhibits. So that's going to give us our 15 minutes. I want to review that so I can be brought up to speed because the transcript, from what I understand, is just a transcript with suggestions of what defense wants to redact. Is that correct?
That's correct, Your Honor. And so what I would suggest, well, if this works for the court, is we will email to the court staff something we've already given the state, which is the proposed redacted version of the transcript. I understand that the state wants a video to be presented as evidence. We can get there if the court concludes there should be redactions. It's not redacted through blackout, it's highlighted. So the highlights are the proposed defense redactions, and Mr. Ellis can make sure that your court staff receive that, and it can either be emailed to you or printed out, whatever works.
Any objections, Ms. Hunt, from the court reviewing the proposed redactions in order to bring the court up to speed at whatever argument the court may entertain?
No, Judge, but I want to clarify for the record and for myself, is the court ruling on my procedural objections, and I want to reserve the right to make my substantive arguments using what's actually in the exhibit. So being able to quote directly from it, knowing that if it's not a closed hearing, those portions of what I'm saying are going to be on the record and broadcast.
So the court is not making a ruling right now. We're just going to take a break, and then we're going to come back on the record. But on the break, I'm trying to maximize the time, and that's why I'm asking, is there any objection to me reviewing what it sounds like defense has sent you, which is just the transcript highlighting what they're anticipating redacting? I just want to bring myself up to speed, so on the next step, when I make my ruling, the court is ready to go.
Okay,
and maximizing the time, because we also want to put up a monitor, so there's like 3 things we can accomplish in the space of 15
Fair
minutes.
enough. The state has no objection to that.
All right, Mr. Novak, if you wouldn't mind sending what you sent to the state to the court for review, and we will take a 15-minute break. It is now, well, let's go a little bit longer, just I want to make sure everything is in place. Let's come back at 3 o'clock,
20 minutes.
and we'll proceed from there. Court is in a brief recess.
This is a crucial 20 minutes for those of us who are watching this remotely, not in the courtroom. We do have a court watcher in court. Selena Kay is there. She's citizen number 2 out of 15 that we're allowed in today. So we would get to hear at least what she's able to observe from her vantage point. But this is an issue that the media lawyer argued very, very well. And the law supports his argument. Utah presumes there's openness, presumes that public records are open to the media and there should be able to be seen. And the power that's given to a judge to limit that openness is, if you look in the terminology that's used in the law, it's regulated very tightly. It's controlled tightly. It's supposed to be exercised in the most limited fashion possible. Only excluding from media the limited portions that you should. There's no surprise here. The defense wants the media out. They literally filed a motion to not allow media, period, in the entire trial, start to finish. They would love it if the newspaper couldn't even write a story about it. They want the media out, and they're fighting that at every front. Why? Because the judge allows them to. Now, the judge has been a little more assertive today. Judge Graff, he's come in and said, hey, here's my role. This is what I'm doing. Don't put this on me, Mr. Defense. Mr. Novak is saying that, because you told me I wasn't going to look at the papers right then, you gave it back. That means you didn't want us to file motions in limine. Don't dump that on me. I'm not telling you how to run your case. That's on you. But we're hoping here that the media wins this one. If they do not, and I think they know this, the media lawyers are excellent, as you've seen every time. Like this is the 3rd or 4th time they've gotten up in this hearing alone, not to mention the previous ones where they've spoken, at length. If they lose on this front, I believe, like yesterday, it would be an improper decision, and I'm basing that on on what I assume is in the video, because I don't know. We haven't seen it. There's a chance that there is something that should be excluded, but not for the reason of, it would make jury selection harder. Then you have longer jury selection. Then you get a bigger jury pool. Or, heaven forbid, you move the trial to a different venue. You have options to do that, but the presumption, the right to the public view on this is right up there. Okay. Stay hydrated. Stay hydrated. Yes, we will. 20 minutes, 16 minutes now left for the judge to review this. He's reviewing the copy of the transcript, which is a transcript made of the video of the interrogation or questioning of Lance Twiggs. The state has objected on a couple different reasons. I counted, 7 different objections, everything from relevance to the state's testifying, because they're just saying, and then it says this, right? And Lance says yes. And then it says this, right? And Lance says yes. So they're saying it's improper that way because they're testifying, and that shouldn't be admissible. It's not relevant. It violates Mr. Robinson's constitutional rights, which I think the defense believes his constitutional right is to be found not guilty. That's about where I think they stand now. That he should be found, it's his right to be found not guilty in this trial, and any evidence that may indicate that he should be found anything other than that should not be admitted. Cumulative, that was in there. Defense not saying, I mix it up so much, mix it up. We need the transparency. The judge addressed this. If we can just rewind, just hit the rewind button and go back to the media hearing where the judge addressed the media. It was brought up, and out of the judge's mouth, we heard him tell us that the lack of openness, the lack of transparency actually creates more problems in the public. Then you have these harebrained ideas about aliens involved and like FBI, CIA shooters that really are just, that he's the fall guy for some bigger plan. So if you keep everybody in the dark, those mushrooms will grow. And they'll grow and they'll grow. And they'll be a problem. Because people will hear them and think, yeah, no wonder they're keeping it secret. Because this harebrained idea is actually real. It helps to shed light on this. The state law is in our favor. By our, I'm saying the media and the public access to this. I think the argument is in our favor. Even the content, I believe, is in our favor. It sucks for Tyler Robinson because his friend and roommate and, love interest says some stuff that is not going to help him in his case. And Lance said this with qualified immunity, right? Basically, you walk into the interrogation room and they give you a get out of jail free card, and it applies for right now. And they say, between now and when you hand us this card and walk out that door, anything you tell us we will not use against you. Anything you tell us, we will not use against you. Now, if it's something we already knew or something we would have found out anyways through our other investigation, we reserve the right to prosecute you to the fullest extent of the law. But anything you give us that's brand new, we're like, oh, really? That happened? Oh, we had no idea. It cannot be used against you if later down the road we decide to prosecute you. And Lance sung like a canary. He talked. He tweet. He talked to them, and it was all recorded, and we have this. And I think it's great. He had a deal. He took it. It benefits him. Wonderful. But just because he said things that are harmful to Tyler Robinson's case to make him look bad, and that might convince members of the public, if they hear this, that, I guess Tyler really did do it. That does not mean it should not be shown to the public. End of rant. End of rant. We need transparency. Like Rockin' Robin. Yes. Tweedly, Rockin' Robin. The media lawyer needs to keep pushing. SBAR, the next thing they have to do, if they lose this, I think they have grounds to appeal. And the fact that they are being heard in this hearing, even though they're not a party in the hearing, I think may qualify them to appeal to a higher level, just like defense did, right? Just like defense, every time they lose a decision with the judge, they appeal it to the Supreme Court and say, quick, overturn this. We think the judge is wrong. That's the media's next move. Your Honor, things are happening. There's no other remedy. We have fought for this. The law is in our favor. We have argued in front of the judge these points. We've presented case law that supports our facts. We are having our rights violated, and there is no other remedy than going to the Supreme Court and asking you to step in and force them to follow the rule. And by them, I'm talking about the judge. The judge, on the other hand, he has this idea in his head, apparently, this is my perspective, that a hard jury selection means a violation of Tyler Robinson's rights. And it's not. It's not. I think you might have to do more, right? You might have to do a longer, impanel more jurors, potential jurors, send out more questionnaires. It might have to be 750, it might have to be 1,000. I don't know how many. And it might take 2 weeks to find a jury. It sucks. But that's the right move, as opposed to saying, we're going to operate in a vacuum. No one's going to know a thing about this case, at least legitimate stuff. It'll just be speculation out there and whatever, someone's able to, overhear in the elevator. And then we'll pick a jury and all will be good. It won't. It won't. Loves True Crimes. Thank you very much. Appreciate it. Good rant. Interlocutory appeal. I think that's the name of the type of appeal they'd have to file to get a change outside of court to stop this abuse of rights, which I think is happening. And I think they have a solid argument if they went to the judge and saying, Your Honor, the judge can't say, yes, the news media over there can watch, but the news media over there cannot, because I don't like what they're going to do with it. Because let me tell you, news journalists, they are really good at capturing details. They write really fast and they have great memories. That's why we have them as journalists. They observe something happening in real time and they take incredible notes, some of them in shorthand. They have legal pads. They're sitting opposite that room. And if that video is played in court, or if the audio is played in court, some of those journalists will capture every word that is played over that, and we will have a verbatim transcript that could be published by the Deseret News or Salt Lake Tribune or the Davis County Clipper. I don't think they're around anymore. Wow, I banged my elbow on the desk and the whole screen shook. I thought, wow, I have all this power. And how is it fair to have one news media outlet be allowed to do that and the other news media outlet not? Are you picking and choosing winners and losers? That's not fair. If it is going to be shown to the public and the public is allowed to be there, then the media gets to be there. And if the media gets to be there, all of us get to see it. I think that's the way it should be. Somebody asked earlier how I got interested in law. I have been interested in law since I was just a little kid. We're talking junior high. I was in 7th grade, and I think it was my history class, was because of space and the school was full. There were tons of kids, and they put our class in a janitor's closet. It was a small class. It only had about 21 students in it, as opposed to like the 33 or something that was the average. And we were in this little janitor's closet, packed in there, and the windows had been broken out. There was like boards in place of the windows. There was no heating or central air, no heating or cooling, and it was winter. It was freezing cold. And so we'd come to class and we're just like shivering in our desks as we're trying to learn history. Well, I studied the law. I said, this can't be right. And I went and I looked up and I researched. And it's more laborious to do that back in the day. But we researched and found the law and found that there are actually rules in place that say when you can and can't, what conditions have to be in place for when you can hold public school in the state of Utah, which is where I was. And so I printed off everything I could find. I'm highlighting and printing it off, and I grabbed a digital thermometer. I went to school the next day, and I went to class, and I sat down, put the digital thermometer on my desk, waited for it to reach the balance point, which I think it got to like 61 or 59 or something like that. It's chilly, right? It's chilly. And I took the thermometer up to the desk, and I handed my teacher a copy of the law, and he looked at it. And he read the law, and he stood up and he said, class dismissed. And we just all got out and got to leave. And the next day, they had a new classroom for us, which had heating. But that was the moment where the law became powerful for me. Until then, my experience with the law was, seeing somebody get pulled over for speeding, or maybe getting chased when we were toilet papering a friend's house, something like that. But that was the limit of it. And since then, I've always been interested in the law and how it affects us, the making of the laws, the unintended consequences that come about when we rush reactionary laws into place. And so that's how it started. I've loved it ever since. I've been involved. I've spoken up at the legislature when I felt that a bill that was going through was not right, and I didn't like where it was going. I've spoken in committees about that. I've talked to representatives. I've just loved the whole process. And then as I got older and well, as a teenager, I would sneak into court. We had a little community court down in the basement of the court of the police office, and I didn't know I was allowed in. But I'd ride my bike down there, and I'd like sneak in and just like sit on the back row. It was like I just wanted to watch. I just wanted to see what was happening and try to understand. I didn't know, prosecutor from defense and just the judge would call a name and somebody would stand up and they'd read the charge, and I'm trying to make heads or tails of it. I thought I was getting away with something that was, any day now they're going to cuff me, right? They're going to find out that I shouldn't be here and I'm gone. But I've loved it, and it's always been a love of mine. So that's a little bit of the background of what got me into the law. I then got very interested in the news media. I've worked closely with police departments, done metal detecting for them, for crime scenes, looking for shell casings. I've done videography work for them. I've gone through citizens police academies, done all sorts of stuff. So all that comes together. Went to school for communications, electronic media, worked in the news media for a little bit, and then completely took a turn and went to work for the Department of Defense in a top secret SCI position, which I loved. It was great. Worked my way out of that position and then ended up here in YouTube. So here we are. There's a little background. Welcome, by the way, if you're new. That's a little bit about me. Now you can pretty much answer all the security questions on my my credit applications. All right. With your love of the law, being an attorney wasn't something you wanted to do? No, believe it or not. I love to watch it. I love to learn about it. I have a ton of respect for an attorney who puts themselves out there and is the shield for a client, right? Who stands out there and says, I will defend this person, and do it in a way that they can't defend themselves. That's a huge responsibility. And I've never wanted that on my shoulders, knowing that there's a learning curve, knowing that, I make mistakes and that people's lives are in the balance. That's a tough one for me. I haven't wanted that responsibility, but I do enjoy it. Let's see. Welcome to the new subscribers. Thank you, by the way. We had to study law and democracy in high school. It was a great course. You know what class I wish I paid more attention in, Karen? It was economics. My teacher was amazing. He taught me how to stock walk fly fishing, but this was economics class, and we were like learning how to walk while squatted down, holding a pretend fly rod in that class. I don't know why he taught us that, but I think we got extra credit if we could do it. But he took us on a field trip to the Federal Reserve in Salt Lake, and we got to go inside these rooms where they're moving pallets of $100 bills. Like, there are forklifts carrying more money around than any of us have ever seen. Okay, Mr. Beast, his eyes would have fallen out of his head. This was what he has as small potatoes compared to rooms just stacked high of cash, just greenbacks, and then watching them shred money was just amazing, just unbelievable. Anyway, fun times. Money's heavy, yeah. What was the make and model of your first car? Mark Bass, filling out that security application. 1976 Ford Country Squire station wagon with fake wood paneling. There you go. Have I missed anything spicy or good testimony? You've missed a big argument. We've actually got 3 minutes before they come back. We are waiting on pins and needles to see if we will get to see or hear, or both see and hear, Lance Twiggs' interview. His 1102, his statement to police, which is in video form and covers 22 pages of transcript. Yeah, you guys, the next time you ask me what the last four of my social is, us being able to hear and see it will force the media to report things properly. There were people saying the DNA was more of Twiggs than Robinson, but that wasn't true. Mr. Beast has truckloads of money. I can tell you, because my kids have been on some of his videos, the money he uses has to be fake. It's all fake money on the videos. I mean, he gives away a real amount, but for the videos, it's fake paper money. And finally, mother's maiden name. I think I've actually shared this somewhere. Yeah, I need to lock down my credit. It's about time to have a sponsor from what is it, LifeLock or something? Somebody needs to hook me up with them so we can lock up the my credit history. It's all good. It's all good. This is why I can't buy a house. You guys ruined my credit. I love this ribbon hoarder. And first of all, I love your name as well. Ribbon hoarder is hilarious. All my security questions answers are lies and totally unrelated to the question. If you do LifeLock, you won't get spam calls anymore. I'm not sure if even LifeLock can stop that. Seriously, is Twiggs his real last name? That's what it is officially on the records. I'm not sure if it was changed to that or if he changed it, but I believe, yes, that is Lance Twiggs is his legal name. Mendy Lou says, thanks for this insight. I wish you guys would see what attorneys don't do. All the motions, brief, documents, discovery, etc., but yet they get all the praise. Okay, I'm fine, just venting. The paralegals do the heavy work, the grunt work, the terrible time-intensive tasks, and then the attorney does take all the credit. All right, just checking on our time frame. We are straight up 5 o'clock. The judge should be back now if he's reviewed all the highlighted portions that the defense gave him on this 1102. It's 100% true. Even the lawyers admit it. They're like, yep, I remember when I was a paralegal, I did all the work and my boss came in and took all the credit and he got an award and a raise and now he's partner and you know, and it was me that did it all. So, yeah, that's how it works. Rank has its privileges a little bit. When I worked for the federal government, there's a program where employees can save money, save the government money, and get a percentage for the money they saved as a bonus. It's a really cool program. It's an incentive for efficiency, right? And we need that in the government. So I'm not against this. I made some changes to how our system monitored and alerted and checked for false alerts on some monitoring, because we did server monitoring. And it eliminated thousands of hours of overtime pay because we didn't call all these system administrators over the weekends. It saved hundreds of thousands of dollars over a year. My boss got a great award for this work, and she retired. I'm not sure if the two are connected, but I got an attaboy. As a contractor working for the federal government, I'm not eligible to receive any awards. They can't even directly thank me for the work I'm doing or say I'm doing a good job. All right, let's see. You replaced workers with AI? No, this was before AI. I mean, the closest thing we had to AI, I was running Splunk, which does log monitoring. Right, Splunk's a fun software. It can everything that you turn on that has any sort of computer in it, from your fridge to your microwave to computers, cell phones, cars. It saves logs, and Splunk takes those logs in their native form and understands them and finds the correlations and allows you to say, for instance, determine just from somebody logging into their computer if they sped to work that morning. And you're like, how does it do that? It can, and I can explain it sometime, but it's amazing. It can find just great bits of information. All right, I'm getting a spam call. I can't take it because we're about to come back to court. Judge said 5 o'clock. Yes, it's 5 o'clock on the East Coast, 3 o'clock in Utah. This was the time the judge should be done. Splunk is an unfortunate name. Yeah, but it's like spelunking, right? When you're deep dive into the cave. I think that's where they get it from. Have you used Splunk? It's a lot of fun. It's expensive. You start adding all those search heads and ingesting a whole bunch of data, and it gets really expensive really quick. I devised a system to streamline medical billing efficiently, and that landed me in a layoff. Changed careers to patient care. Was it DC9 coding or something? That's spelunking. I know, but I think it's related. It's like maybe splunk is the sound that a log file makes when it's dropped. All right, fun times. ICD-10. See, my wife did it when I was 9. I think someone's told me that before, and I didn't remember. But any second now, we'll be back. The judge has taken a 20-minute break to review. Here we go, I think the cameraman's getting ready to flip the audio on and pan down. Just waiting for the judge to bang the gavel. The judge took a 20-minute break to review the document the defense put forward, that is the transcript of the Lance Twiggs interview, 1102 statement, with highlighted redactions. So the judge can see what they want to redact. The defense, making all their objections, which I said there were 7 of them, did not list anything specifically other than that the classification of the objection. They didn't tie it to a line or a statement, and they've actually gone so far as to say we need to have a closed hearing because even me saying what the line was defeats the purpose, and then it violates my client's rights. He can't have a fair trial because now I had to argue in public court about closing this, and that forced us to reveal what it was, and now the cat's out of the bag, and it's history. So we'll have this argument. I don't know if we're going to finish this argument tonight. It's going to be spicy, and I do hope that the media weighs in at least one more time, especially if it goes against us. But can you catch the door? But it's going to be good. Love the gavel. I love the judge uses the gavel. So many judges have one just for decoration only, and Judge Graff, every start and close, you can count on it. It's going to happen. He's going to bang the gavel. I don't know how we're going to finish this prelim. I don't think we are. We've got 2 more witnesses for the state, which I don't think we're going to finish Mr. Davis today. And then at least 2 witnesses for the defense. I imagine once we get to the defense, the objections from the state aren't going to be quite as, is obnoxious the word? No, that's not a good word, but the objections the defense are making are extremely time-consuming to address, whereas the objections the state has been moving have been more, this is our position, and the judge can look at it and say, and decide. Want to hear it all? Me too. I love that the judge told the defense, you want to do it at sidebar? Really? That just means that they have to wait a week to file a request for sidebar, and they get it. They get the whole printout. You really want to do it at sidebar? And he's like, no, never mind, I don't. I thought sidebar was private. It's not. I want to do it under sealed hearing. So now we've got a motion to close the hearing, which would kick everyone out, by the way. Not just us. It would kick everyone except for possibly the victim advocate. That they might be able to stay. And the attorneys out. But the public would be gone. All the media would be gone. The news reporter, the still photographer, the cameraman, everyone's gone. And then they'd proceed. And I really, really hope it doesn't go that way, because that would cause problems. Sending prayers, says Goodman Law Firm. Thank you, Nicole. This prelim is like being stuck on It's a Small World. It just keeps going and going. It's a very small Ferris wheel. There's like 6 chairs, and it's just spinning and spinning. I like obnoxious as the descriptor for the defense objections. What are the prayers for? Oh, Josh tonight. We'll link to Josh last night as well. I love his takes on this. I think he starts at 8 p.m. I'll have to check. 8 p.m. Eastern time, which is in 3 hours. But I can't wait if he goes on a rant. I've got to see that. I missed what the prayers were for. I see them there. Oh, right here. 80s music. We need to pray for someone I know there in the RA community that's going through a stressful time with their mom in the hospital. Oh, man, can't speak the name. Private reason, just pray. 80s, thank you very much. Appreciate it. For those that don't know, 80s Music Man, he has a blue shield by his courthouse. He is an OG. He's been around since the very beginning. Long-time supporter of the channel. And appreciate you making us aware. It's always good to remember that, well, some of us might be having a really good day. Others of us come here because they're having a really bad day and they're looking for some company and some friends or something to take their mind off a lot of the pressures and stress and the realities that they're facing in life. So what does OG mean? We like to say it means original GOAT, or a couple of us say it's original gangster. But GOAT is greatest of all time. This is somebody who has been with the channel for more than 20 months. It's just we picked this number out of the air. If you've been here longer than 20 months, you're an OG. It relates to, I think it's like a gamer terminology, computer gamer terminology, and it's basically a signification that you've been around long enough that you get some of the inside jokes on the channel, and you've been here for some of the unique experience where the judge plays us in court live, or where we get cited in a case, or a witness calls in and says they solved the case. We've had some pretty crazy stuff happen on this channel, where we got admitted in evidence as a screenshot from this live stream in a trial. So that's OG. Woody Cincy, you are an OG. 38 months. Lots of OGs in the house. But Laura, you also are an OG for sure. All right. Let's see. I like Josh's rants. Oh my goodness. I'm going to vote for Josh on this one. Purple Coconut. If I get a say, which I think I do, I think Josh's rants are fantastic. Let's see, the media got this. I hope. The delay's taking longer. Pamela, welcome. Good to have you here. We're a lot of friends. We don't always agree on everything. I'll put that out there. This is not an echo chamber where we only allow one viewpoint to be shared. But we do ask that if you have, a different viewpoint than maybe the predominant one in chat or something, we just ask that you share it respectfully. You might not convince us at the end of the day, and we might not convince you. And that's okay. This isn't really the place to force everyone to think the way that you do. Share it respectfully, and it's welcome and great. We try not to do any name calling and be respectful of court, knowing that our live stream and what we do every day is viewed by courts across the country as we are applying for media access in other courts. So how we conduct ourselves reflects on us and affects what we get to do in the future. Thank you, Pamela. Allie, hey, I just wanted to say I made it to be OG. I am captivating. I'm OG and loving it. 39 months. That's OGest of OGs there. Amber's rants are fire. She's good as well. I think I missed a couple in there. Allie, thank you very much. Appreciate you. Let's see. Oh, Britt Bottoms. There it is. A gifted membership. Thank you very much, Britt. Appreciate that. The rants are based in law, logic, reason, and blinding red passionate for those things. Yeah, and we try to make it, this might sound like some of you might laugh out loud when you hear this, but we try to make it family friendly. I happen to know that there are, families out there that let their kids watch court with us because this is a relatively safe area where they can learn about the legal system. And I'm a huge fan of that. Man, I wish I had a setting where I could learn about courts and how the legal system worked, aside from just me sneaking into traffic court, the little court down in my city growing up when I was young. So I love it. Because of that, we do try to keep the curse words and innuendo and everything to a minimum. Obviously, what happens in court can get spicy, but generally people understand that. So. Appreciate that. Been lurking since Daryl Brooks, been a member on and off through the time. Baseball dad, that means you are an OG. Daryl Brooks was our first official case that we followed on this channel. The very first one. You might have seen me in some commentary and some other channels during the Johnny Depp or a couple of the other big trials that happened around that time, because I was in chat before I started live streaming to Daryl Brooks. Call myself an armchair lawyer. That's awesome, Shelley. Letitia Stout. Oh, yeah. Brooks was a rough one. Yeah, but he had like a box fort. All right. I'm currently watching your entire coverage of Aaron Dean. Oh, potato smiley face. That was one that I struggled with the outcome. It's terrible. I believe the victim in that case was Tatiana Jefferson, right? She was in the house. Aaron Dean was a responding police officer. They got a call, suspicious. They were concerned about a break-in. The door was open late at night. The officer, investigating, went in the backyard. He thought he saw someone inside breaking in with a gun. The person inside had heard noises outside. The person inside was the homeowner. So she had drawn her gun because there was somebody in her backyard, and Aaron Dean shot and killed her through her window, through her bedroom window. Just a terrible case. A terrible case. I think he's almost halfway through. Didn't he get a 10-year sentence? I think he got a 10-year sentence on that one. I don't know. I'm sorry if I just ruined it for you. My apologies. Sorry. I did not even think that through. But I think Peter Tragos mentioned you, so I came and checked your channel. I've been here ever since. Peter Tragos was amazing. Got to be on his channel once. It was a lot of fun. He's a great lawyer. I loved when his dad weighs in on legal issues. I like that he is not afraid to share his opinion, even when sometimes most of chat disagrees with him, and he's great that way. I love him. He's genuine on screen and off. The same character, the same personality. Plus, he's got a warm space in his heart for North Carolina, which is where I live. So that's cool. Yeah, spoiler alert. I'm sorry about that. Let's see. We did not cover the Rittenhouse trial, but we did cover the Zachariah Anderson trial, which was the same judge, Judge Schroeder. And that's when he played our live stream in court while the jury was walking in. So everybody heard it. Like, you heard me on Law and Crime and Court TV and everything else. And that's where we got the soundbite that says, I think it's this one. Hang on, if I can find it. This one. Nope. Now I can't find it. Well, the one that says, now we're hearing commentary on the case. That was the judge talking about my commentary. Let's see. Used to watch Emily D. Baker. Just got tired of her interruptions. I love Emily D. Baker. I'm sorry. She can be a very spicy. Obviously, she's got the cursey words, but she's got great insight, great production value, and the way she's able to connect with her audience, and everything from her app to, just her honesty and keeping us up to date what's going on with her family and kids and things. She's fantastic. One of the pillars of LawTube. And she gave me some good advice early on, which I followed. Not directly, but good advice. Found you through Rob on Law and Lumber. That's awesome. EDB is smart, incredibly smart. I have not gone to CrimeCon yet. I've got some feelings on that. I would like to go. Here's how I feel. I happen to know very well what my demographic is on YouTube. Basically, YouTube tells me the age, gender, and location, generally, not specifically, not to the individual, of the people who view the channel. And I happen to know that many viewers, like the vast majority, are in a category where they're probably at the later end or past their working years, and a lot of them are on fixed incomes. A lot of them don't have that just that free cash to do what you want to do. Hey, let's go down to CrimeCon type thing, and I've resisted doing that. Because I don't want to put pressure on other people to think, hey, well, I've always wanted to do a meetup, and I have to go there to do it. I'd like to do a meetup that's cheaper, if there's an option that comes about. CrimeCon sounds amazing, and there's just incredible people there. I'm not one for really sitting and listening to lectures, so I'd probably skip that part, but going around and meeting people, I'd love it. Outside the demographic in pretty much all aspects. That's cool. Yeah, it's just the majority, not all of them. How much longer? As long as the judge takes to read through those 20 pages that the defense offered him and highlighted for him. I found LawTube seeing some dude with white hair with an alpaca at the Deb v. Heard on 6 p.m. Sydney News. I was hooked. Okay, stop. I'm trying to remember who this is. This sounds like something I should remember. White hair with an alpaca. Alpaca at Deb v. Heard. Depp v. Heard. CrimeCon's in Florida. Marciana, I stumbled onto your channel during the Cavalcante manhunt. He was found 4 miles from my home. Marciana, that was an amazing experience. We took a break from watching court and started providing coverage of the manhunt and updates about what was going on. It was like a perfect storm as well, because the local law enforcement was doing I'll say a terrible job updating locals about what was actually happening in their community. They basically said, hey, there's an escaped inmate and he might be in this neighborhood, so y'all just look out. And then they just left it at that. And all they knew was there were sirens going here and there and helicopters overhead. And so we tried to make heads or tails of that and provide information, not up to the second, but relevant information that would help people understand what was happening, what areas they were searching, what leads they were going on, and things like that. And it was a blast. We met a lot of really cool people in a lot of different professions, truck drivers, just residents in the area that called in from all around that area. It was a blast. I've got a huge representation of channel members still from that area that stuck with us after the manhunt. All right. The demographics are us retired people. Nobody else has time to watch during the day. All right. I wish you did local cases like in Raleigh, Wilson, or even your county. There's some good ones to follow. Brooke, there are, and we're trying. North Carolina is a tough one. My county here in Pitt County, I've been to the courthouse. We've talked to the court clerks and tried to get in, talk to the judges, try to. They basically they say we've never really televised, even though it's legal, right? Even though they can, they're like, we just don't do that. I'm like, well, I'm asking you to do that. No, we just don't do that. Is the response we get. So I've got a friend who's a lawyer right across the street. We've been to his place. I'd love to follow some of the cases he deals with, because he deals with some pretty heavy ones. But it's just been difficult to get the court to allow us in. It was your uncle of the Bailey. It wasn't his alpaca, but it was the case that he met Rob from Lawn Lumber. Okay, it wasn't his alpaca. That makes more sense. So the elf from the True North. Ian came down from Canada. The alpaca was just part of the Depp v. Heard circus outside. Okay. Ian Runkle with an alpaca. If somebody has that picture, text it to me. That would be fun to see. Let's see. Unfortunately, says Tiffany, not retired, but rotting in a desk where people leave me alone so I can watch. I worked in a cubicle for many, many years. It's not fun, but there's some good work out there, and some of it pays well as well. So I do hope you enjoy the work you do. Life is so much more enjoyable if you do enjoy the work you do. And I realize not everyone has that benefit or that blessing in their life where going to work is something that they look forward to instead of dread. I'm grateful every day that I get to do this because I do love it. I get to play with tech toys. I have a lot of fun toys to play with. I love it. I get to play with those and talk to you guys and hang out and watch court. And it's phenomenal. It's the best job ever. All right. Stay-at-home mom with a 4-year-old went to labor after a chiropractor appointment and never went back. Britt Bottoms, that's awesome. Being a mom is the best and highest calling, I think, in the world. It's amazing. And I say that because I've watched my wife, not because I personally am one. My wife is incredible. Love that you get to stay at home with your child. Joe, thank you very much. It's been many years acquiring all these toys, slowly, one piece at a time. Sometimes wait a few months and be able to get another toy, wait a few months. But we have managed to get to the point where we have a fly pack. We can go on the road, remote. We did just in this last month, a couple of weeks ago, end up going up to a jail takeover, and we were up there on scene for that. It happened just about an hour from me, but that was a good test run of what we can do. So we'll be doing some more of that. So did they decide to do their closed hearing? They haven't decided yet. As a matter of fact, that argument isn't even finished. 44 minutes in now, waiting for the judge to come back. I think he phoned a friend. He had to have phoned a friend. No one talks about how isolating being a stay-at-home mom can be. I'm glad I get to be home with my wife. There's something about when I worked. I remember my wife, being at home with the kids all day, and I'm coming home like, "Hey, I'm home," and she's like, she loves our kids, like loves. She's like, "I just need a little bit of adult conversation, just something intellectual, something stimulating, something that will just It's been Legos and fart jokes all day, and I'm just done. Right, I'm just done with that part. So it's good fun. She's amazing. Kimmy Sue, you figured it out. Work from home past 20 years. You were working from home before it was cool, pre-COVID. I got that opportunity as well. It was amazing to let's see. Just missed a call from North Carolina. Hang on 1 second. Oh, nope, that's okay. Someone was asking me about Jonathan Gerlach. Grave robbing, human remains trafficking case. Do they have a case? Do they have a date on this one yet? The Gerlach case? It's in Delaware, PA. He waived formal agreement on Wednesday. That was, this is 2 months ago. I don't know if there's a date on this one. If somebody knows of that Gerlach case, the grave robber incident, we'd love to see if that goes forward. How late is court running now? My Mountain View, this court is in Utah, so if you're on the East Coast, they are 2 hours behind us. So when it's 5:30 here, it's 3:30 there. But this judge had a little break that I think he's coming back from right now. Hold for a second. Got a lot of motion in court, people coming in and kicking the tripod. He took a little break that it was going to be 15 minutes, extended it to 20. was going to come back at the top of the hour. That was 28 minutes ago he was going to be done. So we're 48 minutes now into the break. And during that break, he was going to read the proposed redactions by the defense. But I'm really wondering if he's just phoning a friend, and I'm trying to figure out what to do here, because he has sort of created a situation where the defense is controlling the narrative as to what he considers. And this could have been laid to bed, put to rest early on in the hearing with a blanket media coverage ruling, and with a little different understanding about the role of what happens here, and specifically a little more understanding about Mr. Robinson's right to a fair trial and how anything shown here can preserve that right can be preserved through extended jury selection process. Yeah, you grant extra strikes, so that the defense can strike more witnesses, more potential jurors, with or without cause. You spend more time asking questions. You ask questions about this itself. Did you watch any of the preliminary hearing? Have you heard anything about the evidence from this case? Have you seen videos of a roommate of the accused? You can ask questions to find out if the jury has been tainted or has seen some of that. And even if they have, okay, because a lot of times jury members can say, yeah, I remember hearing about this back when it happened, when the arrest went down. It was a big deal. Even if that happened, it doesn't mean that juror is automatically off. Now, if they can be struck without cause, using up one of the strikes from the prosecution to defense, that would get rid of them. But if they can then say, yeah, I heard about it a little bit, but I can set that aside and be impartial. I can walk into this and say, anything I heard before may or may not have been accurate and may or may not have been true. So I'm coming in brand new. I'm not going to base my decision on anything I might have heard or felt before. That still needs. PA doesn't stream any cases. No. Did you watch pretrial for this case? We've watched almost all the pretrials for Tyler Robinson. I think there's been one or two. The judge does some, he announces some things sometimes that we didn't follow. But people are going to want to be on the jury. Yeah, I don't think we want to have people that want to be on this jury. It sounds like they might have already made their mind up. Kat, I would not be surprised if they have trouble finding non-biased jurors in their current jurisdiction, in Provo, in Utah County. I think they're gonna struggle there, and there may be a very passionate and legitimate argument put forward by the defense for a change of venue, but they have to be careful about that change of venue. Because there are only a couple options. Utah has something. If you look at the state of Utah, up near the top, up near the little narrow part on the top, there's the Great Salt Lake, and to the east of the Great Salt Lake, there's a mountain range, and between that mountain range and the Great Salt Lake is the Wasatch Front, and it stretches a little bit up past the lake and down well past south of it. But most of the population in Utah is in those areas. And then we have, down in the center, you've got some Cedar City, Moab type things. And down in the bottom left-hand corner, you've got St. George, which has a lot of people. But other than that, there are vast stretches with nothing but desert. It is desert land with no people. And so if you say we want to change a venue, you might be saying, okay, we're going from Utah County to one county north, which is Salt Lake County. That might be beneficial. It's a big county. The courtroom can hold it. It's where they did the Olympics. It can handle the press and everything else. They've got great facilities that way. You might say we might want to go up to Summit County, which is the other side of the mountain range, up in the ski resort area where Park City is, where the Corey Richards trial was. It could go there. We could go 2 counties north to Davis County, which is it's more of it's a residential community for the most part. That's where the people who work in Salt Lake live, and it's very expensive. It's nice, It's way too expensive for me to live there. So like the average small home, I think is, I don't know, $650,000 or something like that. It's crazy that way. Or you could go, a little bit further up into Weber County. But anything further than that, I don't really see them making that switch. Weber County is where you get up north of Hill Air Force Base, and you've got college. It's an older town. Ogden up there was an old train station town back in the day. So there aren't a lot of options. It's not like you can say, well, we could go anywhere in the state, because some of these counties, I mean, you can count the number of registered voters on just a few hands. I'm kidding, of course, but it's mostly just farmland, grassland, grazing, or just desert or mining or something. All right, extended recess, a long one, a very long one. We're now 5:34. We're coming close to, I think we're coming close to a 50-minute break, just over a 50-minute. Okay, I'm not taking spam calls right now. So no court today now. No, we're coming back. We're coming back. We're just waiting for the judge to finish whatever he's doing in chambers during this break. The only other thing they were supposed to do was, hang on. That's not spam. Hello? Hello? That was Selena. That was not spam. That was Selena. Selena, call me back. Hang on one second. I think they're on an indefinite break. What's going on with the court? The judge is trying to decide some things. Let's see. Nope, that was not Selena. Okay, we're good. Missed all today. Any good updates? Yogi, we're potentially moments away from getting the most bombshell of bombshell evidence that we've seen so far. So far, I'd say the big stuff that we've heard in this preliminary hearing over the last 2 days is that Lance's DNA was also found on the screwdriver and the towel, and possibly the gun that was wrapped around the towel, and that we got some extra footage from security cameras that we hadn't seen before. We had seen screen grabs from some of them, but we actually got to see the footage. That's the big stuff that we've got. We have found out a little bit of information about how the arrest went down, how he turned himself in, who was there. We've seen a little bit of video of Tyler Robinson as he was at the police station in custody down there in southern Utah, but haven't seen any audio. This would be the big moment. This 1102 video and the text messages, or any communication back and forth in the group chat with Lance. This is going to be the smoking gun. This is the big item. So we're waiting for that right now, and the judge has to make some decisions to see if we get to see it or hear it. Let's see. So it could get really important really quickly, but it was supposed to be a 20-minute break, and it's nearly an hour now. Wow, life is rough. There's no meaning. There's no meaning. That's why it's funny for the kids. At this rate, the hearing won't be over by Friday. I agree. Amber, let me know what you hear. You've got my ear, so. Let's see. Thanks, Red, for the update on Gerlach. I'm starting to really think he closed the proceedings. I don't think he can. Utah law requires a hearing to close proceedings, and that hearing is public. So he can't close a hearing. Thought they handled this in a hearing prior to this. a lot of the issues the defense is raising now have been raised before and were addressed and ruled on, and the defense is raising them again. So it's the judge is allowing it instead of just saying we stand on this unless you can prove under this narrow rule why this should be excluded. We're going with the original ruling. That's what he should do, in my opinion. So we're still seeing that shake is from people walking around and stepping near or kick. Oh, here we go. Here we go. Here we go. We're back. Almost an hour.
Court is back in session.
Gavel.
Noting the presence of counsel and all parties, I appreciate your patience. Sometimes it takes time to save time, and so that was the intent of this court.
His nameplate's back.
In addressing
missing earlier.
What is before this court as it relates to State's Exhibit 16. Counsel, in this time I've taken time to look at the video anew, also reviewing what Mr. Novak submitted, the redactions requested, and reviewing all parts of it in great detail. All right, I want to address the objections before me, and starting with Mr. Novak made a hearsay objection as it relates to Mr. McBride, and the court agrees, it is hearsay. At the same time,
it's admissible. It's reliable
I'm
hearsay.
only going to consider Mr. McBride's statements to provide context for the things that Lance Twiggs says and for their effects on Lance Twiggs. And as such, the hearsay objection as it relates to the statements of Mr. McBride in State's Exhibit 16 is overruled. Turning to relevance as it relates to State's Exhibit 16. And I agree in part and disagree in part as it relates to this objection. So there are portions of the transcript, or I say transcript, but what I really mean is State's Exhibit 16. And I appreciate the transcript. I found that to be helpful. It's a lot faster than trying to scroll. And so I appreciate that being provided. It was helpful to the court. And to be fair, I found it to be a true and accurate representation of the actual recording. So did I listen to every word and compare it? No, but from what I reviewed, I did not find any inconsistencies, just to put it on the record so there's no misunderstanding. But there are portions of the transcript, State's Exhibit 16, which relevance is still not clear to me. However, as the magistrate, I am able to distinguish between what is relevant to a probable cause determination and what is not. And what I take into consideration when I make my ultimate decision about probable cause, I will not take into consideration what is not relevant. So that is a constant balancing and evaluation I'm making throughout this hearing. And after this hearing, my intent is to review everything again, to be thorough. This is not a case where I'm going to be shooting from the hip in making that determination, because this is an important determination. So I will take the necessary time as is required and is as necessary to ensure that the constitutional rights of all parties are upheld. So as I'm making determinations, where I land is pages 19 and 20 of the transcript as it relates to State Exhibit 16 may contain irrelevant information, but I will reserve whether I consider those portions until I've heard the rest of the state's evidence. Therefore, as it relates to relevance, that ruling is reserved. Now, turning to the other objection, which is Rule 403, prejudice. As I am acting as a magistrate, I do not have the same concerns that my decision will be influenced by undue prejudice as that of a jury. Therefore, for purposes of admissibility, the defendant's objection is overruled. Even so, there are portions of this transcript, and again, State's Exhibit 16, that may not be admissible at trial and whose relevance I have not yet determined. In the abundance of caution and to protect the jury pool, the potential jury pool, from hearing potentially inadmissible evidence, I'm ordering that the audio cannot be published in the courtroom or on camera from page 19, timestamp 3255, until timestamp 3548. In other words, the state may publish the audio for all portions of the interview other than that one portion. And when I say audio, I mean audio and video. So both. I recognize there's approximately only
About
1
3
minute
minutes.
after 3548. The state can fast forward to that point for it's an approximate 1 minute and 12 seconds, or may take the time to redact the video as they see fit. So where I'm landing today is up until from the beginning until that page 19.
So the first 32 minutes are admissible.
3255, that portion I am ruling is admissible and may be published. Again, if the state wishes that last minute and 12 seconds to be played, they can either take the time tonight to redact what the court is not going to allow to be published. And I wish to differentiate. I'm considering it all. But for publication purposes, that portion is not going to be permitted to be played in the courtroom.
Your Honor, would you state those times again that you are ordering now?
3255 to 3548.
3548.
Right. Those are the two timestamps for that. And I hope that's helpful as both parties are trying to review on the transcript and State's Exhibit 16.
And that's from 3255 to 3548.
Right.
Okay, thank you.
Is not publishable in the courtroom or on to be broadcast. Finally, I want to recognize both parties wanted the benefit of the record to be more specific in their arguments concerning their objections. So if those arguments pertain to timestamp 3255 through timestamp 3548, I'm willing to allow you to do that in a closed hearing. Please be mindful of the time and keep your argument succinct. With that in mind, do the parties have any arguments they feel I have not considered in my ruling that require a closed hearing?
Defense wanders slowly. He's confused.
Yes, Your Honor. And so I'm just going to tell the court what I think the general nature of that is without getting into the details, because
Sure.
I do think a closed hearing is appropriate. There are, okay, setting aside the 1102 issue and objections, there are statements in this video by Mr. Twiggs attributed to Mr. Robinson. Okay? Mr. Robinson said. There are two other exhibits, which I've said before, I'm confident the state will offer, which Mr. Twiggs says in this video, those are statements by Mr. Robinson. Okay? I will acknowledge that separate and apart from 1102, the statements of a party opponent are admissible if relevant. In fact, they're not even hearsay, right? They're excluded from the hearsay rule. But the question is whether statements of Mr. Robinson of the nature that I'm referring to can be published, not considered by the court, but published without violating Mr. Robinson's 14th Amendment due process rights. And it is our view, as we have said in our earlier papers, that the answer is no. Publication, especially on in the way this proceeding is being published, would violate Mr. Robinson's due process rights under the 14th Amendment.
How?
We previously cited, and the reason why I'm saying this again is not to reiterate something just because if you say it twice, it means something different, but because my colleagues have suggested that maybe my argument earlier was not clear enough. And so I want to make sure it is clear so that the court makes a decision based on the arguments of counsel. The United States Supreme Court said in Estes, E-S-T-E-S versus Texas, 381 U.S. 532 the following.
Equal protection.
In Rideau versus Louisiana, and that's RIDEAU, this court constructed a rule that the televising of a defendant in the act of confessing to a crime was inherently invalid under the Due Process Clause of the 14th Amendment, even without a showing of prejudice or a demonstration of the nexus between the televised confession and the trial. I am not calling the statements of Mr. Robinson confessions, but that is what the state will call them. And so there are portions of this exhibit and the other exhibits that I've referred to which implicate Mr. Robinson's right not to have what the state calls a confession televised.
Where does he
This
get that
court
right?
has authorized the televising of this proceeding. And there are reporters in this courtroom who will go outside and speak on what we used to call television. That opinion was from the 60s. Now we have other forms of technology, but I'm just going to use what the Supreme Court says because it's the Supreme Court. So we are very concerned that the publication beyond this court's eyes of what the state will call confessions at trial violates Mr. Robinson's due process rights right here and now today. And I know that we said that before in the litigation, but now we're exhibit specific. If I haven't been clear about the argument, I want to make sure I'm clear about it because the court's decision to allow this video to be televised and the other two exhibits to be shown to the camera in the back of the courtroom is exactly what the Supreme Court says violates the 14th Amendment.
Somebody grab a frame grab of
I
that.
appreciate that clarity, and perhaps, and again, if you want to go into closed hearing, we can do so, or if you want to refer to the pages. So I want to know exactly what you're referring to, whether it's in that 3255 through 3548, which is being excluded, or is it in the
It is not. It is earlier, and it's also the two other anticipated exhibits. So we may as well deal with all of it at the same time. It's probably easier to do it in a closed proceeding because nobody has to be obtuse. I don't have to be obtuse in order to protect my client's rights.
No, I appreciate that. And it actually prompts, in order for me to get to that, I do want to ask the state, are you intending to introduce the text messages as an exhibit in this proceeding, the preliminary hearing?
Yes, Judge, we will be attempting to and moving for the admission of the text thread, the Discord thread, and I think, and the note that is referenced in Mr. Twiggs 1102.
All right, and let me take one step at a time, just for clarity. And again, Mr. Novak, I really do appreciate you being so precise. It's helping me parse it out so we can address it, because it's important, and I recognize that you're advocating for your client, and so I want to give it its due time. The text messages, from my understanding, and either side weigh in, my understanding that those were released to the public months ago in their entirety.
Judge, if I may, they were not released in their entirety. Portions of them were placed into the charging document, the information that supported, in part, the charges that the state has filed. We did not put the entirety of them in. And now we wish to publish more of them than were included in the charging document.
I see. For some reason, I thought it was as part of an exhibit for a motion, but Mr. Novak, I'm not sure if that's ringing any bells.
I'm aware of the issue that the court is commenting on. I think the state needs to account for its decision to publish text messages that directly implicate the Supreme Court law that we're talking about. And don't want to pretend that I can anticipate what the court's concerns are, but that doesn't cure republication on television of what the state will call a confession in this proceeding. So in other words, this is not like, oh, the cat's out of the bag or the barn door's open. This is another opportunity to violate Mr. Robinson's constitutional rights. And I'm not at all suggesting that somebody is intending to do that, certainly not the court, and I'm confident that the state's counsel would never intend to do that, but that would be the consequence of further televising what the state refers to as, previously referred to as confessions, and certainly would refer to here in this proceeding as confessions. We are so acknowledging that they are statements of a party.
Without due process
We
of
have
law.
not filed anything in this case that publicizes the text messages, the Discord chat.
Of course not.
The note which Ms. Hunt is mentioning, and now that Ms. Hunt has said that, yes, we want this note to be presented into
We're gonna
evidence.
object
and
to
the
that,
court knows
too.
what this note is because if the court's now watched the video. That's another piece of the same problem. So this is all simplified by the court being extra cautious about Mr. Robinson's constitutional rights, considering these exhibits to the extent the court deems that they're admissible and portions of them are relevant, and not further televising them in this proceeding in a manner which we think is inconsistent with what the Supreme Court said in Estes v. Texas.
He doesn't have a right to privacy.
I appreciate that, Mr.
That this
Novak.
not be published.
Ms. Hunt, would you like to respond? Because I understand what Mr. Novak's saying, and there may be a 403 issue as well as it relates to this, and I'm not going to pretend to read your mind, but because I can't do that. All right, Ms. Hunt.
Just to clarify for the record in the court, the state's position is that we would like the audio played. The audio may be captured by the cameras in the state's position, but we never intended to visually put them on the monitors such that cameras can capture them and pause or get the actual exhibits, substances of the exhibits. I believe that was the media's position, if I remember correctly, is that they want everything
Yes.
audio and visually displayed, but the state's position is we just want the audio played.
Right, but what's it? So I'm just focused on 16 right now.
Okay, yes, and that's the state's position with regards to Exhibit 16.
All right, so help me understand, what's the difference if the audio's played or the video's played on what the court is identifying is, well, first of all, 16 is admitted, so that threshold has been met, but we're dealing with the publication in regards to what is publicized, because this is going to Mr. Novak's argument about publicizing that is different than the court simply reviewing it in its own privacy.
Mr. Novak, sit down. It's not your turn.
I don't want to misstate your argument, but I believe that was one of the distinctions you made.
The distinction that Ms. Hunt is drawing is, I think, what people call a distinction without a difference. It doesn't matter whether it's audio or video, and it doesn't matter whether it's on a television or on the internet or on the radio. It's going to be broadcast. And so it doesn't really matter whether it's audio or video. And it's actually not Mr. Robinson's video, it's Mr. Twig's video.
So you don't have
And
standing
when the court
to
mentioned
object.
403, yes, I think the court did accurately read my mind, which is fine with me. But it's unfair prejudice of a constitutional dimension, and 403 is a rule of evidence.
All right, so Ms. Hunt, as it relates to that publication, help me understand whether it's audio or video. What's the difference there? Help me understand that.
I disagree that it's a distinction without a difference. As we've discussed prior in this hearing, UCJA Rule 4-202.02 sub 2 sub J states that exhibits are presumed to be public court records, and it does give the court discretion to regulate access when necessary to protect the integrity of the exhibit or ensure a fair trial. So I do want to recognize that. But that discretion should be exercised narrowly, as we've talked about before with publication regarding this case. What the state is proposing, we believe, is a narrowly tailored accommodation. We don't want to display the full exhibits. Obviously, within State's Exhibit 16, the video of Lance Twiggs, he is shown, and it can be seen, exhibits that the state will then, in the future, move to admit 16.1, 16.2, the text threads, the Discord threads. So we're thinking that if it's displayed visually, what the cameras will be able to do is pause that, duplicate them, replicate them, essentially have access to those exhibits. What we're trying to do, and maybe they can do the same thing with I'm sure Mr. Novak will say they'll do the same thing with the audio. But hearing the tone, the context, all of that, that's why the state chose to do, we could have done a written 1102 statement from Mr. Twiggs. We chose to do, as is allowed by 1102, we chose to do a recording because that's how the state is choosing to present this evidence. We believe that the appearance or the tone, the context, hearing Mr. Twiggs actually talk and talk through these exhibits, talk through his experience, is a meaningful way of presenting our evidence. And so that's the difference we're seeing.
I see.
Obviously, it's up to the court's discretion on how publication is to be made here. We've made our arguments generally about that issue, and we'll submit it to the court. Our prime issue is that the exhibits be admitted into the record, that the court consider them as part of the preliminary hearing standard and bind over, but we'll submit it to the court on publication. But that's the state's position.
All right, Mr. Novak.
I learned a long time ago that when the opposing party says, Your Honor, we're submitting on it, there's a suggestion that maybe the court is going to make a ruling which doesn't require more evidence, more argument from me. But I am going to say that it is fair for Ms. Hunt to say, Your Honor, we wanted the court to see the witness and hear the witness so that the court could make reliability determinations. Because as Your Honor has said, that's really up to you. That's a different issue from the constitutional consequences of electronically publishing what the state will call a confession. Now, I've changed the word from television to electronically publishing because I'm trying to be in the 21st century, and the Supreme Court used that word in 1963.
Welcome to the internet.
Citation to state standards for what is or is not a public document are not the issue. There's a constitutional issue here. And I think that the court has already heard from me at least 3 times about what we think the court should do here. It's a preliminary hearing. It's not a jury trial. There may be a jury trial in the future at which we have to voir dire on yet another issue, which is whether potential jurors were exposed to media replaying of what the state called a confession. That's exactly what was structural error. There was no prejudice question in Rideau versus Louisiana, and that's why in Estes v. Texas, the Supreme Court said, we have a rule. You can't televise what a prosecutor calls a confession before trial. Thank you.
All right, thank you. I appreciate both parties advocating and arguing. It's helpful for the court.
The judge is tired. I like that he got his sign back. It was missing earlier today. During the break, they put it back. Judge Tony F. Graff, Jr. Media has not weighed in on this one directly since their first appearance here today. we've seen some of these messages. We've seen some of the statements, some of the discord. I think pieces of this were released, but not to the extent that the state wants to do today. And there may even be more that the state is not releasing
so
today.
in taking into consideration the argument, which again, I appreciate the parties articulating, the further edits that the court is going to require to be redacted, starting on page 8, and I apologize, I don't have a timestamp. Starting on page 8,
This won't be played today, no.
and, sorry, I'm just trying to,
They're cutting out the confession part.
sorry, starting on page 7, right after, is that at 8? Well, let's start. Starting on page 6.
There it goes. We're losing pages as we speak.
Now,
Now page 5.
here. Starting on page 6, after 6 minutes and 56 seconds. Going to 20 minutes and 27 seconds. For reasons such as 403, under Rule 403. And again, this is simply for publication. This is not taking out what the court will consider. The court is considering the entirety of State's Exhibit 16, but the court is trying to take a narrow approach in recognizing and balancing transparency with constitutional rights, and doing so in such a manner that it is meaningful and doesn't diminish the court's duty as a magistrate under the probable cause determination. All right.
Restate those times again, Your Honor.
6:56 until right the line before 2027. Or 2027, just so until 2027.
So we just lost another 14 minutes of video.
And then what the court indicated previously from $32.55 until $35.48.
And I apologize, Judge, just to clarify, these timestamps that you just gave, the 32:55 to 35:48 and 6:56 to 20:27, those are just not being published, but they have been admitted for Your Honor's consideration.
The whole thing's
Right,
admitted.
so kind of going through my three-step process. Exhibit 16 is an entirety, not the transcript, but because the exhibit is not the transcript. The exhibit is the video. That has been admitted in its entirety for the court's determination as it relates to this case. So what I'm talking about here is this is only what will be published in the courtroom and and captured by the video is the differentiation. So what's being redacted, for the lack of a better word, or cut out is what's going to be published in the courtroom, not what the court's going to consider. The court's considering it in its entirety. The court's not going to redact anything in here. It's going to make its own determinations in regards to relevance, everything that Mr.
All the objections.
Everything that Mr. Novak noted, I'm taking that in consideration and making those determinations, which the court will do again, because this is not something you do watch once and then make your decision. This requires analysis, and the court is committed to doing that. But hopefully that gives you an idea of where, as it relates to publication.
Yes, thank you.
All right, to the media.
You need to file on
Your Honor, I know how much time the court's already dedicated to considering this, and I appreciate the additional time being afforded the media. There's just two additional things that I wanted to mention to the court. I do want to reiterate the point that I made before about the fact that if this is, in fact, a key consideration that the court is entering into when trying to make the determination that it is going to make at the conclusion of this hearing, Utah case law, including the Archuleta case, that the defense has referred to over and over again, stresses that the same considerations that urge for access to a preliminary hearing itself, allowing the proceedings to be televised, allowing people to be in the courtroom, also advocate for access to documents on which the court bases its ruling. Disclosing documents used, this is from Archuleta on page 238 to 239. Disclosing documents used by courts in reaching a decision in a preliminary hearing will discourage decisions based on improper means and will promote conscientious performance by all officials involved in the criminal justice system. Therefore, providing a presumptive right of access to documents filed in connection with preliminary hearings can play a significant positive role in the functioning of that process. I do want to reiterate the belief that providing access to the documents on which the court bases its decision in this proceeding is critical. Second thing that I do want to mention, because the court referred to it before, is the fact that without going into the content of the interview itself, I understand from the arguments being made today that many of these references are to text messages. Again, the public doesn't yet have access to that. But I do believe that the documents filed in this case, including the information that was filed days after this, contain many, if not all, of the text messages that are now at issue that are going to be kept from the public in this proceeding. I know the court in previous occasions has said, if this information is in the public already, I shouldn't be in the business of trying to now keep that from the public for two reasons. One, it's already out there. Second, it suggests to the public that something else lurks in there. Something else is being kept from them that isn't. And so not only does it run counter to the idea that, of transparency generally, but it seems to suggest that there is something embedded in there that the public doesn't already have access to when the court denies access to materials in a proceeding like this that are already public. And so I again, recognizing how much time the court has already invested in this, I believe it's wise, and I believe it would help avoid potentially making a mistake that the court later on then thought, oh, I wish someone had brought that to my attention, to check whether or not any of the materials that are now under consideration to be withheld from the public are actually already in the public's domain because they are part of the information and probable cause statements that were filed at the outset of this case. That's all I had, Your Honor.
Thank you. And, all right. Counsel, if you would like to state your name.
Who's this? Oh, yes.
Your Honor, Jeffrey Nyman on behalf of the Kirk family. I've been very hesitant to speak up at these proceedings. We understand the state, the defense, and the judge, you're all doing your job. But I feel as if we need to. I want to be clear as to what the Kirk's family's position is on all of this. The Kirk family believes strongly that if the evidence is being admitted in this preliminary hearing, it should be made public for the world to see. No redactions. This court has tools at its tools at its disposal to make sure the defendant receives a fair trial. You'll use them if you find that you need to. That's it, Your Honor. To not be transparent here, to not be open, to not let the world see what happened, will create doubt and distrust in the judicial system.
He doesn't do deal.
And that's not what anybody wants. That's not what any of us believe should happen here. and we'd ask the court to consider the position of the family in making its ultimate decision.
Thank you. Anything further before I issue my final ruling to clarify what's been stated, just so it's clear to all parties? Mr. Novak?
Oh, wow.
Your mic's muted.
Yes, we just want to say
Family's not
that
on
we
trial.
totally respect Ms. Kirk's position in this situation, as well stated by her counsel.
But this is a trial where my client's on trial, not the family.
Media counsel's suggestion that because the state, in our view, improperly disclosed what the state is going to call a confession in charging documents does not mean that this court can just let it go. This has been the most transparent criminal proceeding I've ever been involved in, and I am sure it will continue to be transparent. But there are some things which the Supreme Court has said the public has to wait for the jury trial in order to hear evidence, because the number one preeminent question is how do we protect Mr. Robinson's right to a fair trial? And with all due respect to the Kirk family, and with all due respect to the media, and with all due respect to the public, the number one concern in this proceeding is Mr. Robinson's right to a fair trial, which means a jury which has not been exposed before it's in this courtroom, under this court's supervision, with this court's guidance, to pretrial information of this nature.
All right, I do have a follow-up question for you, Mr. Novak, returning to the Estes case. It's an important point. I want to make sure I fully understand it before I issue my final ruling. My understanding is Estes cited to a dissenting opinion in Rideau.
Rideau, yes.
Rideau. My French is bad.
Mine too.
That constructed a rule that publicizing a confession runs afoul of the 14th Amendment. But that didn't appear to be the holding. It was the opinion talked about coerced confessions being put out to the public. Could you cite to Estes that supports...
The portion that the court is looking at is exactly what I would read to the court. It says, we constructed a rule. Now, I understand there's a parentheses there where it refers to a dissenting opinion in Rideau, because I think that was a case where there were multiple opinions. And we all understand how complicated it is to figure out what comes out of a Supreme Court opinion when there are multiple concurring and dissenting opinions.
Mm-hmm.
But what the court says in Estes is that televising, I'm going to paraphrase a little bit, televising what the prosecution calls a confession de facto violates a defendant's 14th Amendment right to due process without a prejudice analysis, without even looking at what happened in the trial vis-a-vis that earlier televised analysis. So yes, we could go down what lawyers like to do, we could go down the rabbit hole of what were all the different opinions in Rideau and why is Estes citing to a dissenting justice. But what Estes said is we constructed a rule. It's not a reference to a dissenting opinion. And I think when the Supreme Court says we have a rule, we should just take it at face value that that's the rule. I understand what's in parentheses there is a little confusing, but what the Supreme Court is saying in Estes is we have a rule. And if I may have one moment.
Yeah, those parentheses might be very, very important. All the moments are used up. We spent the rest of the day arguing this, and we still haven't seen
the Estes opinion was written by Justice Clark. There was a concurrence by Chief Justice Warren, Mr. Justice Douglas, Mr. Justice Goldberg, And then there were dissents by Justices Stewart, Black, Brennan, and White. So we could spend some time deconstructing that, but it's a 5-4 opinion of the United States Supreme Court saying what rule they adopted in Rudeau versus Louisiana. It's a 5-4 opinion.
So it's close to a split decision as you can.
And I would have to sit down with the cases, just like Your Honor probably is wishing it had time to do right now. The court had time to do right now, but it's a 5-4 opinion of the United States Supreme Court saying what the holding in Rudeau is.
Thank you. All right, I appreciate that guidance, Mr. Novak. So, taking into consideration all the factors, the previous edits, starting at, I believe I said, starting at 6 minutes and 56 seconds, going to
2027, what you said before.
20 minutes and 27 seconds. Does that comport what I previously said?
Yes.
All right. And then the other edit is
$32.55 to $35.48, Judge.
from 32:55 until 35:48. Does that comport with what I previously said?
Yes.
All right. And then from 35:48 to the remainder 37 can be included. So there is that gap, but that can be included. And part of the reason in responding to the media, and it's an important point, and to the representative for victim representative Erica Kirk, is I recognize the importance of transparency. I also recognize the importance of balancing constitutional rights, and it is a fine line. One of the reasons why for these edits includes under my analysis under 403, going to the last part, needlessly presenting cumulative evidence. And based off the representation of the state that the text messages may be introduced, the court is ruling that this may be revisited in case that doesn't happen. But to throw back the curtain, much of this is the text messages, to be clear. And again, all of this is going to be considered by the court. I'm balancing all these competing rules, the constitutional rights, as well as transparency. And sometimes it is an imperfect balancing act. But I'm trying to act in the interest of justice in making this balancing act and for transparency to actually be transparent. And so that is the ruling of the court as it relates to State's Exhibit 16. Turning to the state, do you wish to make the edits as identified by the court and play it tomorrow to publish it?
Because we're out of time today.
Do you wish to go a different route?
I think just to make sure that we are completely in line with the court's ruling, I think we would like to take the evening to make sure the edits are all correct and start out tomorrow by playing it.
And if you wouldn't mind, when you have that final copy, if you could send it to defense to review to us to form, just to make sure it comports with the timestamps that the court has identified. And I know this has been a long conversation, but I just want to make sure everyone understands, okay, this is what the court said, and we're all on the same page, that what is before that's being presented reflects that. So not downing the state, simply allowing everyone to review it before it is introduced into court.
Absolutely, we will do that.
All right.
Oh, sorry. We're courtroom confidential.
On this issue,
we're going to portal to
anything
it when
further?
we're done today.
As to this exhibit, none.
All right. Well, Ms. Hunt, let us move forward. Being that you indicated that you're going to prepare this for tomorrow, how would we like to proceed for the remainder of our time together?
If you're going to have just a moment.
Of course.
We sort of needed this to ask the next questions of this witness, I think. I can almost promise you the parts the judge is keeping out of this, the statements that are attributed to Tyler
I know
Robinson.
the state's
in this-
engaged, but if someone could send a copy of that to the court after it's been reviewed by counsel, so the court can review it to double check that it comports with what I said, to make sure that it reflects what I was intending to reflect. That way we can save time as well.
Those parts that are cut out that we're not going to
Thank you.
hear, those are most likely going to be the first words out of the prosecutor's mouth in the opening statements of the trial. So if there's something that's like, I did it, I did it, I did it, that's how they're going to open their that's when we're going to hear if this goes to trial. So we'll see. I think there should be an appeal filed. I'm not saying the judge.
Judge, it's the state's position that we close for today, come back once those edits have been made. We can start tomorrow with that and proceed from there.
All right. Any opposition from defense?
No, Your Honor. I do want to point out that there is one additional exhibit which we think the state will offer through Mr. Davis. I'm sorry, Agent Davis. Agent Davis.
Where did he go? He sat down.
As to which we proposed redactions. It's 5 screenshots of Mr. Twiggs's phone. It's not a 25-page transcript. I'm not suggesting that we should argue about that now, but I'm just making the court aware of that. It's a much simpler exercise. It's not nearly as complicated. I think that's the only one where we proposed other redactions. But the publication question still remains as to all of the asserted statements by Mr. Robinson. So it's according to Mr. Twiggs, according to the text messages, according to the Discord, and the note. All of that is part of the SD's issue. And I just want the court to be aware of that. And I understand it's hard because the court doesn't have all those exhibits in front of it. But I just want the court to understand. I think that all of the argument that we've had with respect to the transcript sort of lays the foundation for the legal issues, but it's going to come up with respect to those exhibits as well. And the comments that the court made about 403, I understand it with respect to relevance and admissibility, but I'm not sure how 403 applies to the televising of statements that the prosecution will call confessions. So maybe that's something.
It was a different prong that I was addressing.
Good, okay.
The duplicative part or cumulative part as it relates to the text messages, and that's why I reserved that if it doesn't come in, then it can be revisited to the redactions that's made public.
For evidentiary purposes as opposed to for publication purposes.
Right.
Understood.
Right.
But if the court wants to recess, we have no problem with that.
And so just going to your point, and again, trying to maximize our efficiency, given your arguments, which you articulated well, would you mind perhaps preparing a memorandum or a short brief that can help us move forward? Because I want to look at in detail what you're citing to. It's difficult on the fly to jump into SDs and go to a portion, and I want to give your argument full consideration. It's a suggestion if you can. I know you're extremely busy, but it may be helpful if you choose to. If you choose not to, I will certainly allow the time for it to argument. I just want to make sure I'm fully up to speed as opposed to trying to shoot from the hip there.
When the court says, I'd like to know which exhibits and what the legal issues are ahead of time so that at 9 a.m. the court has already had an opportunity to understand what's coming, we're happy to do that. And I'll try to get something to the court by 8 a.m.
I appreciate that. Thank you, Mr. Novak. And if you would mind, obviously,
paralegals will be
sending
at
a
work.
copy to the state as well.
Oh, of
so
course,
it's not
of course.
Ex parte. All right.
So, is the court referring to a formal filing?
No, just if
A
you
bench
want
memo.
a bench memo, and that all sides can have a take a look at, just to prepare, again, in light of
Bench
efficiency and trying to maximize our time and give as much weight and time to addressing these issues fully, as opposed to trying to hit them at the moment and doing a deep dive when it's a little bit more difficult. So
happy to do so.
If you'd like to, I would entertain that to the state. If you want to confer and talk to see where you are and want to do the same, certainly you are entitled to do so as well.
I think we plan on doing that. Thank you, Judge.
All right. All right. Is there anything else for this afternoon?
Does anyone need the benefit of the record?
To defense.
No, thank you very much for your time, Your Honor.
Ready for the gavel?
Court will be in recess until 9 o'clock tomorrow morning.
There it is. 9 o'clock tomorrow morning. We got nowhere. That objection counter, I just gave up. The objections became a little bit obscure as this went on because defense does not want to object with specificity because doing so would require citing the part they object to, and that's what they don't want having come out. So they do these vague objections where we have issues with this on 403, and the judge is like, "Show me where." Right? Can you highlight? Can you just point me to a timestamp or something? What are you talking about? And they're like, well, we want to do a closed hearing. The judge said we can do a closed hearing if you want, but he didn't ever hold the hearing on the closed hearing. The media gets to weigh in on that. We need all the goats to scream. I only have 2 working screaming goats right now, and one is a Halloween goat. There we go. That's the birthday song today. Greeners, you did. Happy birthday, Greeners, to your little one. Thanks for sharing the pictures in Mod Chat. She is just cute as a button. We're so excited for you and your family. Tell Mrs. Greeners that just amazing. So happy for your family. Thanks for sharing and sharing the news with us. And also we sang to Baby P, Uncle Josh, baby nephew. I won the mod pool on Baby Greeners. Had your wife had the baby yesterday, Red Pen would have been held liable to a promise she made, but she didn't. And I don't take that up with it's not Mrs. Greener's fault. I mean, I'm not saying she did anything wrong. Let me say this. We've made some progress in this trial. We will start, assuming the edits get made appropriately, we will start tomorrow. And I have to actually shut some things down. Hold on just one second. We'll shut down Top Mark Media. We've got a call. Hang on. It's Selena.
To accept, press 1. To send a voicemail.
Hey, Selena, are you there? Hang on.
No, I'm Stuart, not Selena. Are you Recovery Addict? I've been waiting to talk about the Tyler Robinson trial.
Stuart, who is this? Stuart, how are you doing?
I'm doing great, thanks. So, am I live on air now? I want to discuss the Tyler Robinson trial. Total miscarriage of justice. Clear conspiracy, if you ask me.
All right. I hear a Stewie from the Family Guy. Is that what I'm listening to?
No, I'm Stuart from Waynesville, North Carolina, not Stewie. Let's focus on Tyler Robinson, wrongly accused, if you ask me, victims of the 14th and a half Amendment, clearly a setup.
I have no idea who this is. It's weird. I've got to take this off the air until we can find a little bit more about you. Call me back or lose the voice changer. So we'll see you. Sorry. We need something else. That was somebody's playing with AI and voice changers. So I think it might have been, I don't know, Phil. Phil, where are you, Phil? We're waiting for Selena K to call. I'm sorry. This is the problem. This is the problem we have when we publish my personal phone number on the internet. We went what 4 years, and then it happened today. So, Stewie. I don't know who that was. Yeah, that sounded definitely AI something going on there. I'm not sure what. All right, one more thing. Let me do this. We've made progress. Someone needs to out themselves, and even in private, if you don't want me to tell you who was that. We made some progress today. Tomorrow we're going to get some video shown. It will be we'll get some audio of Lance Twiggs doing his 1102 video recording. That's going to be the first step. I think there will be some challenges going forward because I think the state's going to ask some questions that are going to based on the evidence that's already admitted, which is this video. I think they have to ask questions of witnesses based on that video to corroborate evidence and say this was the statement made. Was this correct? And so we're going to have some objections from the defense saying you can't say anything from the video because now that's out in the public and you can't do that. We still have that fight to come, and that's going to be epic and long and uneventful. Was that Phil? Was that Phil? Not I. Yeah. Sorry, I was not just uncomfortable. I had to stop the live stream from Top Mark Media because the feed was over. So, anyway, the progress was good. I think the media needs to make a filing, possibly interlocutory appeal. At this point, there are. I think there are enshrined rights in the in the Utah Constitution and in law that might be being violated. I realize the judge has some discretion to make sure to preserve the integrity of the trial and to protect Mr. Robinson's due process, 14th Amendment rights. Right. The whole idea behind that, when the defense gets up and says this violates his due process, they're saying that showing this would make it impossible for Mr. Robinson to have a fair trial. Because the video would get out to everybody, all the potential jurors would see it, and it would make it impossible or very difficult to have a fair trial. And there is no denying that it could make it more difficult. But the way the law is written, it seems to say, that's the price we pay because we have the freedom of the press. And instead the judge says, let's curtail the privileges and the freedom of the press so that we don't have to pay that price. And I think that was the wrong decision. I still stand on that. I think that was wrong. We have decisions where I think that there's an abundance of caution being used when instead the law asks for extremely measured and limited response. And the two cannot coexist, abundance of caution and extremely measured. So we have just too much caution. Even when I'm in the family, I love that Erica Kirk's representative, her lawyer, got up and said, "Judge, we want it all in." I mean, if you just want people to weigh in, we want it all. This is Selena calling. Hang on just 1 second.
Call from Selena.
Selena, what a day.
Oh, my goodness.
I'm so glad you're not a robot named Stewie. That doesn't make sense to you maybe, but the last call we got was a robot named Stewie, so I wanted to talk about the case.
I'm glad I'm not a robot. I don't feel anything like a robot. I feel like I've been through the ringer. Holy moly.
We saw you got the great parking spot right there near the doors again this morning. Saw you walking around a little bit on some of the feeds that were live streamed before court started.
Right. And you don't have to wait for me to call very long.
It's amazing. You are out the door and in your truck and right to your phone. We thought that today you would see some things that we didn't, but apparently nobody saw anything today.
No, it was absolutely unbelievable. Okay, so I don't even know where to begin. Like, what in the world are they fighting so hard to not have that come in?
Yeah. they are fighting hard. This is the defense argument that they've sort of settled on. Now that some of the other issues of reliable hearsay and everything else have been preserved for the record and they're moving on, they are all coming down to this 14th Amendment due process rights of Mr. Robinson. That is, if you read the 14th Amendment, it's the right to, you can't deprive of this without due process of the law, and that should be a fair trial. It shouldn't be a sham trial. It should be fair. And for it to be fair, you need to have an impartial jury. And you can't have an impartial jury if someone has seen a confession by the defendant. That's the defense argument right now. And so, like, if you play this, Judge, if you play this, I realize it's admitted, it's going to be considered. And let me just say, if there's a confession admitted in a preliminary hearing trial, he's probably going to be bound over for trial. But if this confession is played before a jury has been selected, this is going to go viral, right? The moments that we have in text message or Lance saying, I picked up the phone and the first thing he said to me was, "It was me. I did it. I killed him." That is quite prejudicial. I can see that.
Oh yeah,
but
without a doubt,
keeping 20 minutes of this stuff out, 15 minutes here and 10 minutes there, and playing just what's your name? Yes, so this is your address. That's the only part we're going to get. Okay, of this video, it's going to be so skinny.
I know, right? I don't even know what we're going to get to hear in the morning.
We're going to hear that they were roommates, that how long they've been living together, something like that. And as soon as it gets to the substantial stuff, it's whoosh, radio silence.
That's going to be about it. Oh, and were you surprised that the Kirk family attorney went up? I sure was.
I was surprised at the passion he brought. He was the loudest and the closest to yelling we've had in this court today.
Can I tell you, oh my gosh. So he was sitting in the row up just ahead of me, on just a few people down. When he sit down, R.A., he was visibly shaking. And his face was so bright red. He was that angry.
Yeah. The problem
and immediately, Erica, Kirk, and Charlie's parents, Charlie's mom anyway, they just visibly started crying after he sat down.
What's happening is the defense is
making
a little bit of a circus.
And they cried the rest of the hearing until it was over. They were wiping tears and hugging. So
I know this isn't the popular opinion, but I do think that when it comes to who has a say as to what should be published, they're in third place out of three. The victim. The victim is, I think, first is the press. It's enshrined in the Constitution. Second is the defendant. We have to preserve his rights. We put them in order because if the press creates a problem, there are steps that can be fixed, that we can use to fix that. So I think the media comes first, Tyler Robinson comes second, and the family's wishes and desires, influential, appreciated, definitely understand it. I definitely understood, but comes third at the bottom of that list as far as factors to decide and make that decision.
Oh, absolutely. I agreed with you. I was like, whoa. They don't get I was thinking that to myself. I know how it's enough about how these courts work, and as sad as it may be, they don't get to make that kind of argument like that everything needs to be out. And it was that courtroom. You could have, the tension in there was unbelievable.
It's building. Can you imagine when this goes to trial? I said this earlier, but the parts that the judge has already ruled are not coming in, right? Those parts will be the opening line of the prosecution's opening statement.
Oh yeah, for sure.
That is the most impactful. That's the mic drop moment. This is the bombshell evidence, the smoking gun, quite literally in this case. That's going to be, oh my goodness. Only Funsies just gifted 20 memberships, and then Red Pen just gifted 20 memberships.
Woohoo!
Holy
I'm seeing
smokes.
those flying.
The whole screen's full of gifted memberships. Yeah.
I don't like it. I feel bad for the victim's family too, and I unfortunately agree with you that you're right about that, but I can see where they have so much emotion and they lost someone, and I can see them why they got upset today in the courtroom. So,
well, what they're witnessing is, this is the moment they're looking for justice for Charlie, right? That's the family's point, is that's why they're there. There's no other purpose. They're like, we want justice for our family member who was taken from us, and as they watch these proceedings, the defense is dragging them on, first of all, which lengthens the amount of time that this family has to suffer through recounting these events and hearing them talked about and being asked about by the press and it being played on TV and everything. And it makes it worse for the family. And then to see the court, you sort of bow to to Tyler Robinson's rights, where it seems like nothing is being done with Mr. Kirk in mind and what the victim here and the victim's families. It can be quite painful. I do think that the family will get their day in court. I think this will proceed to trial, and even if Mr. Robinson pleads guilty and this doesn't go through a full trial, there would still be a sentencing trial, right? There would still be a presentation of the facts for the sentence, because I think a jury has to determine death penalty in Utah. A judge can't do that. And
that's when they get their say. And I think the judge made the right call today with that, cutting some of that out, because I think it was going to be very damning. I think it was going to be his confession.
Yeah.
That they were fighting about. And I love the media attorney. He's a rock
so good.
star.
Both of them are fantastic.
Oh my gosh, they're fighting so hard for our rights as a public and media, and I mean, it's just, I just love them.
Yeah, I'll say this: we have two very good attorneys who understand the law as relates to media specifically. These are not the guys you would call up and say, "Hey, I've got this, going through divorce. Can you help me out?" This is what they do. This is their specialty. It's media law, and they handle big issues with big, powerful players like this, including the courts and the media entities and the coalition. In this case, the media coalition. I think right now they need to file an interlocutory appeal. They need to go higher and say, Your Honor, we are having what we feel is the media rights that are enshrined in law violated. We think that the decision goes too far, and run it up the flagpole. It does sort of slap the face of the judge a little bit, because you're like, well, I'm going to your boss, and he's going to tell you to do it my way. That could cause problems down the road, so they have to be careful about that sort of decision. But Selena, I was hoping for more that you could watch. Tell me a little bit about who was there today and who wasn't there in the audience. We did not get to see much of that.
Okay, Don Jr. was not.
Okay.
There were no media took our wristband spots today, so that was good.
Good.
So everybody that got in was actually a member of the public.
And you had 15 public seats. Those are the yellow wristbands. Media was wearing red, right?
14. We got 14.
Okay.
And mine was yellow. Yeah, ours are yellow. But this is just crazy nuts how people can ruin things. So I guess yesterday someone bought some bracelets at the party store, a party store that was matching. Yeah. Yes, and they tried to sneak in with them. And Chris is a friend of mine. I've known him since Corey, so we've become friends. He is the state security guy.
Yeah.
For all the court. And he was telling me the story, and he's like, and we know who two of them are, and they're going to be criminally charged for that.
Wow. I wonder what is it trespass at that point?
Trespass.
It's a public
Trespass.
It's a public building, so I'm not sure how that works. But that's interesting.
I think it's trespassing because the judge has set down the rules for that courtroom, and
It might be contempt. I could see contempt, where the judge says this is the way it's supposed to go, and you violated that. But interesting.
and today he wrote a number on my wristband, has a 1, 2, like a 6-digit number, and he matched that with his paper. So he went ahead and did that today. So
wow.
And that's going to happen from now on.
They're going to have to specially print, instead of just using these color bands that you can buy at the dollar store, something else.
Who would have thought? It gets crazier. Like at Corey, when they're sketching the jury, and now people are trying to sneak their way in with the
It's
wristband.
never a dull moment in court. Even when the proceedings are slow, there's always something going on. Selena,
I know.
are you going to try to come back tomorrow? It's going to be a big day. We're going to get the text messages.
Oh, I am. I am going to be there tomorrow. I have been waiting for Briggs, and so I want to be there. I want to hear whatever we're going to get to hear of his.
Yeah. Interesting. Selena, thank you very much. Appreciate being a court watcher. Can I share what you shared with me?
Yes.
Selena's starting a blog. She's been a court watcher for us in a couple high-profile cases. She loves it. The court bug bites, and it bites hard, and it's infectious. And so she'll be starting a blog. I'm not sure if it's a vlog or a blog, but we're going to help her out a little bit.
Right now, I have a Facebook page that people could look up and ask to join. And it is Selena, the Court Watcher.
Yeah, and it's awesome. We're super excited. Love that you get to go to court.
So everybody go join it.
There you go. Maybe we'll share a link at one point. So maybe later this week if you can send me one.
And I'm going to I'm going to go home, and I don't know if I'll probably work on my blog tomorrow while I'm sitting there for 6 hours waiting. I got it somewhat set up today. A lady that I stepped by, she made my brand. Isn't that cool? I love it.
It looks so good. It looks awesome.
It looks so professional. I'm like, she did that with Chat GPT, and just like all of a sudden, I'm like, wow. She's like, does this look good? I'm like,
it looks really
are
neat.
you kidding me? Yeah.
We're excited for
So anyway,
you. It's fun. I love
thank
being there in
you.
court. Can't wait to hear more of your adventures that way. Selena, drive safe.
Yeah.
We'll talk to you tomorrow, okay? Get some
Okay,
rest.
thank you again. All right, bye everyone.
Bye.
No, Don Jr. was not there. I see that question just at the very end. So
Gotcha.
he won't be there the rest of the week.
All right, thanks a lot. We'll see you, Selena.
Okay, all right.
Bye.
Bye, everyone.
Amber, you're live on the air. How are you doing?
I'm good. Let me mute my TV. Hang on.
You know the rules.
I know, but Mom's got the remote.
Hey, Mom. How's it going?
Well, now she can't hear you because she muted the TV. So put it on speaker so I can hear. Hi everybody. And I'm not going to stay on here too long because I've got a migraine and it's been a really long day outside of court for me. Couple of things. We're seeing lots of folks get really rude in chat. Let's not do that here. You can take that somewhere else.
Appreciate that. Thank you.
We're timing folks out for 24 hours. We mean business. We're not putting up with it here. You can do that somewhere else. Thank you. I just want to clarify something. Preliminary hearing, correct me if I'm wrong, somebody.
Yes, go.
This is for admissibility of evidence to see if evidence was obtained legally to be considered for a defendant at trial, not necessarily to prove guilt or innocence yet at this point. It's just to see if it was obtained legally to be admissible to be considered at trial.
It might even be less than that.
Right.
This is the equivalent of a grand jury, with the judge being in place of the grand jury and the public being in place of closed doors. It's just to see if the state has enough evidence under a probable cause standard, which is much, much, much lower right? Probable cause standard to bind him over for trial and have a court. That's it. And so we allow reliable hearsay. We allow in evidence that may not come in at court. Just like in grand juries, we're like, can you believe that they said this to the grand jury and it was wrong? It happens. There's all sorts of stuff that gets into a grand jury that would never make it in court. The same rules sort of apply here. So this arguing about who gets to see what and everything, the only issue at play is because this is broadcast, because this is media in the courtroom, does it violate Mr. Robinson's right to a fair trial? Everything else, all these other, this shouldn't come in, this is hearsay, this was taken without his permission, everything, that, gone, out the window. That's not the place for this argument. It should be very, very quick. And honestly, we should be at day 4 right now instead of, we should be done with day 4 right now instead of day 3, with how much time we've spent arguing issues that I really think were not timely to this proceeding.
Right. Now, with all of that said, and very well articulated, because I couldn't do all of that right now with this headache. And thank you, everybody, for the well wishes. I do see them. Bear with me, because I'm incredibly frustrated, like lots of you are. I just haven't been able to voice this through chat throughout the day. So with that being said, the argument of whether or not this evidence is going to be used at trial and presented in front of a jury is premature.
Yeah, very much so. And it will be. I mean, in what world is a confession thrown out? Okay, just think this through out of the trials. In what world is? Hang on, you've got video of my client, committing the crime. Your Honor, you can't. That would prejudice the jury. Right. Yeah, it does. Evidence is prejudicial. That's why it's evidence, and it comes in. Now I can see before trial in this preliminary hearing. Yeah, maybe we shouldn't see all of it. I want to see it all, but maybe we shouldn't, and I'm cool with that. In limited amounts. Don't think we should do all this in the dark. If we did, why not just go back to a grand jury? Why even hold this public hearing with cameras and the courtroom and everybody there and the public and media if you're just gonna every time evidence come in, put it in a garbage bag and have the judge stick his head in to look at it and be like, all right, I've seen it. Next. It doesn't work.
Red, I agree, just FYI. So to that point, Scott, those folks that are saying that the defendant has more rights than the victim, that's not necessarily true, and we're not necessarily arguing for the defendant not to have a fair trial. That's not what we are arguing and are so upset and frustrated about. We are frustrated, those of us that are at a loss for words at this point, like myself, because this particular defendant is getting consideration that folks in small towns that are otherwise unknown to the rest of the world in any way, shape, or form, they would never, ever, ever get. The only reason why we didn't get discovery or public display or publication of evidence in Karen Reed's trials because the state kept it from the defense. It wasn't because it wasn't presented in preliminary hearing. You don't get to keep public from seeing this evidence just because it's going to implicate your client. That's your argument for trial.
Yeah, your client allegedly committing a crime in front of thousands of people implicated your client, and to try to hide that light under a bushel is not very effective. I will say this though, this is not Erica Kirk's trial.
No,
this is Charlie's trial, and while there are interests as a victim that legally Erica Kirk has in this trial, and some of those involve her presence and ability to be there, and inability to exclude her from certain parts of the trial where everyone else could be who was a witness. It is Tyler Robinson's in this case rights that for the most part, play a predominant role at this stage of the trial. Later on in the trial, if this proceeds to trial, if this proceeds to a guilty verdict and then to sentencing, that's where the victim's rights come in and the opportunity for them to speak and to say something and be heard. And then as part of the punishment, the punishment considered their feelings and where they stand and their loss, what they suffered. That's part of the punishment. That's one piece of it. Another piece is to dissuade other people from committing similar crimes, and making everybody whole again, public safety, all that's wrapped into what the punishment is going to be if he's found guilty and he gets to that stage. But oh my goodness, Amber, thank you. It's been a frustrating day.
Yeah, it has.
But we've learned a little bit about the process. How do you just delete his confession? Yeah, you don't. It's coming in.
You can't.
It
you
is
can't.
in. Like literally.
I don't understand, and I'm going to talk with a few folks as well, and I'll of course keep you posted with what I find out. I don't understand unless it's something incredibly graphic in nature that could scar the public or cause undue harm to folks, or in situations like that, I can see if the judge is considering it in a magisterial, you know what I'm trying to say, as a magistrate judge in that role, that's the only hat he should be wearing at this point in time.
There is I think they said at Archuleta, case law that grants judges authority to use discretion, very limited and narrow discretion, to exclude portions of the evidence from public view in a preliminary hearing to preserve the integrity of the evidence. And remember, this is case law back in the days when the media said, we have the right to see everything, and the court said, yep, you do. And they're in there and they're picking up the murder weapon and they're rifling through the notebooks and everything. And they said, it's damaging the evidence. So he can limit the media access to the evidence that way. And there's one little clause in there that says that he can limit the access to the media to preserve the integrity of the trial. And that's where he's looking at it saying, if we do this, it will add 3 weeks on the jury selection process. And so he can make a little decision, but it's not this blanket everything. And especially when stuff's already out, right? How much stuff, we can already go online and see the zoomed video of Tyler Robinson running across the roof of the Losi building and jumping down, or allegedly Tyler Robinson, right? We have to say allegedly. It's already out there. That's already there. We've got screenshots of a lot of this stuff. We've got some of the text messages that were heard, or have like a summary of some of these events. And now we're trying to put the genie back in the bottle and say, we didn't rub that lamp, public. You don't know. The media, you can't talk about this. It's already there. If there was any damage, it's already been done for the most part. There could be some additional damage done because obviously everyone's talking about it again now as we're moving farther along the criminal court process. But I think the remedies that are available to the judge, as the media lawyer pointed out, are in place for a reason, and they're sufficient to fix any potential problem that showing this publicly would cause. So I do think they should do the interlocutory appeal and see if they can get a ruling to open this up and possibly make it retroactive. Give us the copy of the video that we missed yesterday as well. Anyway, that's where I stand.
And at what point? Here's my last question. I'll get off the phone because I know I'm sick of hearing my own voice. At what point does the judge say, this judge or a seasoned judge, at what point does the judge say, sounds like you need to make a motion to sequester the jury?
I can see that happening in this case, for sure.
I mean, really and truly, that's what it's going to come down to. They're worried about prejudicing a future jury for a fair trial. The only way you're going to make sure that happens is if you really sequester a jury.
Yeah.
So if you're not planning to sequester to begin with, all of this fight is for nothing.
Yeah, I think the court should go ahead, as soon as they schedule the court case, just go ahead and book the 4th floor of the Holiday Inn.
Pretty much.
Preemptively. because I think we need to do that, and not because the court feels it's necessary, but because that would speed up the process with the arguments that the defense might file and the objections that they might file. It would be quicker and easier and possibly even cheaper to sequester the jury for as many weeks as this one's going to take, 8-10 weeks, I don't know, than try to fight this out and litigate this and have the issues and potential appeals that would come about if, somebody did a news story and suddenly we've got, a juror heard something while he was at Chick-fil-A and now it's over.
You'll find more folks faster that are able to do a couple of weeks sequestered and are willing to do that than you will unsequestered and untainted at any point during the trial.
Yeah. Amber, thank you very much. Appreciate it. Tell Mom hi. She can turn the volume back up and listen again and rewind.
You're
catch
on
it all.
speaker.
All right.
She can hear you now.
Sounds good. Let's see. Recovery Addict, can you and Amber get in touch with the DA? Let him know that. No. We don't.
No, please don't do that, anybody.
It's not our position to tell the state how to run the case or the judge how to run the case. I will tell you that the one thing I am happy about today, the judge has been paying attention to people, to someone. He's watching. He watched and saw a news clip, or somebody sent him a clip that showed the news was looking at that video screen from the TV sideways, and he addressed it. He said, I can fix that. So he is taking feedback. He might be phoning a friend and saying, hey, fellow judge, a mentor, sir, have you ever run across this issue? Do you have any advice for me? And we are seeing him taking a stronger stand with the defense. We're seeing him really build on previous decisions and stay consistent. And that's a good sign, because this will be the judge for the trial unless something drastic happens. And I'd like to see him. Do well in this trial. This is his first murder trial. First, 1 year on the bench, and he's in his first murder trial. So I think it's great. All right, Amber, thank you very much. Drive safe. We'll see you.
Drive safe. I'm already home. I'll
go for a ride and drive safe then. Okay, I've got a call. I'll let you go.
I'm going to bed.
Bye.
Bye.
All right, we've got another one here.
My name is... To accept. Hello, are you still there, RA?
Who is this? Who is this? Who is this?
This is Red Pen from chat. I've already introduced myself. Are you still there, RA?
What software are you using?
I'm utilizing the latest in telephonic conferencing via Google Voice to discuss the egregious violations of Tyler Robinson's rights under the 37th Amendment regarding avian witness protection.
That's where we lose it. 37th Amendment is out. And we don't allow you to impersonate our mods as well. So we'll go ahead and block that one. All right. All right. I'm sorry. We've got trolls that come through. Yeah, I didn't like that at all. That's let me just say that's not cool. That's not cool. That will shut down phone calls for everybody except for our court watcher if that's what you guys want to do. It's trolling in the worst way. Possibly even criminal. Let me just put that out there. Now they're not going to own up to it. Possibly even criminal. We're gonna end it today. We're gonna portal you over to Josh at Courtroom Confidential, who goes live in just under an hour. I'd like to see his rant, if there is one. I think there will be one. A rant on this, and really, Julia, thank you very much for gifting memberships. Anyway, I lost my train of thought, but tomorrow's going to be a big day. Tomorrow we're going to make some progress. We're going to hear some audio based on the judge's ruling first thing in the morning. By that we mean 11 o'clock Eastern time. It starts 9 o'clock Mountain time. We'll start probably a half an hour to 45 minutes, 15 minutes before then. We'll be live. We'll have the corrected audio stream going on Topmark Media as well. So if anybody needs to get little clips for your Twitter posts or Facebook or something, Topmark Media has the audio in both ears with the volume turned up, but also not too loud. So you can find that if you need that, and you're open to that one. So, all right. with that said, let's play the music and get out of here before the call comes again. Oh, Josh goes live at 8:30. Okay. I look forward to the rant. When you go to Josh, make sure you say hi. He's amazing. We love Courtroom Confidential. The whole team over there is amazing. And he's doing some great work on this one. He's also there in person in Utah County. So that's wonderful. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again tomorrow morning. Hit the like button on your way out if you would. We're just shy of 1,000. If we could get about 120, 117 more likes, we'll hit 1,000. So that would be great if you guys could do that. I will tell you that, let's see, it's the 8th. On the 10th, on Friday, I get my new like counter, and it's going to be a flip chart that automatically flips and counts. It's a Smurl. The goal was to have it set up so that I can see the likes right here, and you can see them when we're on this view. And when you click the like button, you'd actually see the number change. So we might do that. Hopefully we can get it set up right away, maybe for next week. So you guys have a good one. We will see you tomorrow. Love y'all. Bye-bye. We are portaling over to Josh's channel, by the way. Oh, we can portal to Lawyer You Know instead. Hang on, he's live already. Just go from there to Josh's channel. Is that okay? Okay, we're going to Peter Tragos. You guys have a good day.